You cohort. Good morning, everyone, and I know that there'll be other times of the day in other parts of the world, where depending on where you're logging in, and I know that some of our Chinese colleagues will be logging in later. So welcome to everyone, and just to let you know that this is an event organised by the UNESCO Chair in International Law and Cultural Heritage with our partners from 4 universities consortium on cultural heritage law, that is Renmin Law School, Toulouse Law School and Kent Law School. We are hosting the first doctoral colloquium on international cultural heritage law. It's a one-day event, as you will see, with wonderful emerging talent in this field. It's an international event which highlights the research and progress of these emerging scholars in our field of cultural heritage law, with participants from the Asia Pacific region, Europe and the Americas. The program will include, as we will hear shortly, an opening lecture for Professor Lazinski. Before I hand over to my dear colleague, Professor Isabella Alexander, I just want to perhaps give some thoughts as to why we put this colloquium together. It is, I think, an important opportunity. It's been a while since I was a young scholar, but I do remember, especially in this field, that it was one, because it is multidisciplinary and something that feels quite niche in law, that it was difficult to get your research heard and out to other scholars in the field and other disciplines. So we're hoping that this initiative, especially for young scholars, will encourage them to pursue their research in a way that contributes to their societies. So thank you very much for everyone for coming, and I'll hand over to my colleague, Professor Isabella Alexander, who is the Director of Higher Degree Research at the Faculty of Law at UTS. Thank you, Isabella.
Thank you, Anna. I'd like to start by acknowledging the Gadigal people of the Eora Nation, on whose ancestral lands this campus stands. They're the custodians of knowledge for this place, and their sovereignty was never ceded. Welcome, everyone. I'm delighted to have been asked to welcome you all today to this first doctoral convention of the 4 Universities Consortium. As Anna said, I'm the Higher Degree Research Director here at UTS. For those of you who are not familiar with Australian acronyms, Higher Degree Research, HDR, or Higher Degree Research, is what we call the PhD and Masters by Research programs. So it's kind of a handy acronym that encompasses all of those people. And I think it's interesting because we refer to them as researchers, not as students, which is an important part, I think. Here at UTS, we consider our PhDs and our Masters by Research candidates to be an integral part of the scholarly life of the faculty. We have roughly 50 HDRs now, part-time and full-time, and they're doing a range of topics ranging from criminal justice, the rights of First Nations peoples, intellectual property, health law, human rights, international law, and of course, cultural heritage. It's exciting to see 2 of our HDRs here today. Welcome, Lee May and David, who are just in the early stages. And yeah, it's great to see you here. We're also really committed at UTS to widening the international kind of contribution and experience of our students. Next year, we're thrilled to be welcoming our first student in the collaborative degree program that we started with the University of Roma Tre, and I understand there are more international collaborations underway, which is also great. We think of our program as not being just about writing a thesis, although of course that is really important and the kind of the keystone of the experience. But these days, being an HDR student is about research training. So we hopefully encourage people to learn not just how to do research, how to write for scholarly audiences and for different audiences, and how to bring your research to different audiences. And so that's why events like these are so important, speaking to your scholarly community around the world. So welcome to everyone. Thank you to Anna and all the organisers, and for all the participants who are going to make this a fantastic day. I would love to stay for all of it, but unfortunately we're so vibrant here at UTS. And we're actually running another conference in the next door building for the Australia and New Zealand Law and History Society. And as I'm the Vice President of that society, I'm going to have to whiz back and start getting ready for the AGM, and also print up some people's talks for them to technology works well up to a point, and then it doesn't. There's always human error involved. So sorry to have to leave you, but I know it's going to be a great day. Thank you, Anna. Thank you, Lucas.
Thank you.
Great.
Thank you.
Sophie. That's
It's important. We will edit that part. And moving to probably, and to my mind, one of the most wonderful parts of this day. And look, we had an event yesterday with the International Conference, which was really exciting for me because it's new scholarship in an area that's coming up in relation to sustainability and heritage. But it's often inspiring to listen to younger scholars in our field, and that's why I think this opportunity is great. And I've got to say, because I think, Lucas, we've known each other for too long, that you in my mind, it's probably like a parent, you in my mind will always be a young scholar, although I know that you are the leading light probably in the field today. So it is my pleasure, and it was, I don't think I could think of anybody else that I could invite, Lucas, to fill this role that you're about to do, which is the opening talk. But I know that given the depth of Lucas's scholarship and his ideas in this area, that in any other circumstances, because it is such an informal setting, it would be a keynote. So it's my pleasure to introduce Dr. Lucas Luzinski. He is the professor at the Faculty of Law and Justice at the University of New South Wales, Sydney. He works primarily in the field of international cultural heritage law and international human rights. He's vice president conference at the Association of Critical Legal Studies, so I know who I can blame now, a co-convener of the interest group on international law of culture and of the European Society of International Law, and rapporteur of the International Law Association's Committee on Participation in Global Cultural Heritage Governance. He's also sits on editorial boards of the International Journal of Cultural Heritage Studies, the International Journal of Cultural Property, for which I'm deeply grateful, the Santander Art and Culture Law Review. He's also co-editor, and I'm telling you, I don't know how he manages all this, co-editor of the Routledge book series on the international cultural heritage law, and he has published widely, and I can attest to this, in international cultural heritage law. He has multiple publications, including important monographs in this area, the latest being in relation to legalised identities, cultural heritage law, and the shaping of transitional justice, which we had a pleasure of launching not too long ago. So Lucas, it's with deep pleasure that I'm introducing your talk on heritage law, support, renewal, and iconoclasm in the field.
Thank you, Anna, and thank you, everyone. And hi. It's wonderful to speak to you about this relationship between international law and culture from the unceded lands of the Gadigal people of the Eora Nation. As I'm sure you know, Indigenous peoples have long organized their legal claims around the idea of culture. And while that strategy is not without its unintended consequences, thinking about the relationships between cultural heritage and international law on unceded Indigenous lands gives us pause to reflect on the important work that our field does. And especially as it allows communities to galvanize their identities and rally behind certain possibilities of emancipatory action. As the Australian peoples prepare for a referendum on an Indigenous voice to Parliament that promises to afford some balance to Indigenous and non-Indigenous legal and political relations in this country, the role of cultural heritage in providing the ongoing, improving the ongoing existence, survival, and sovereignty of Indigenous peoples becomes even more apparent. I would like to therefore take this opportunity to call for reflection and action on the power of cultural heritage to serve Indigenous communities and other disadvantaged groups in Australia and everywhere in the world, and to pay my respects to the true owners of the lands on which we congregate, even on Zoom. Thank you, Anna, Clementine, Sophie, and Wang for the invitation. It's an honor to stand as the conduit here between the people whose work have inspired me and that have asked me to try and inspire the next generation of scholars in the field. As I speak to you all today, please understand that I stand on the shoulders of giants and that I hope one day you will render me absolutely, completely obsolete by standing on the shoulders of your own giants and saying further than I ever could. I'm terribly excited to learn from you and to gaze into the future of the field through the eyes of those doing the work that will go further, think bigger, and be braver. So thank you all for being here and for doing the important work that you're doing. What I want to do today is map what I see as the zeitgeist of international heritage law, or of heritage law more broadly. I want to focus on the key basic assumptions and pillars of how we imagine the law's relationship to heritage and identity. Having identified these basic assumptions, I will attempt their conceptual archaeologies with a view to exposing the stakes of what we deem to be heritage, what it is for, and who it serves, using the language of the law. I will then contrast these archaeologies to the major and somewhat cliched challenges that currently overlay much of our rhetoric around heritage, such as the Anthropocene, renewed calls for interdisciplinary engagement, the resurgent interest in the safeguarding of heritage during conflict, and pathways for the enforcement of heritage law globally through mechanisms like international criminal law. These desirable goals, while important in their own right, could also benefit from being contrasted to the archaeology of our key concepts in the field as a means of asking a fundamental question. As the field keeps on growing, can we build upon past successes, or do we need to rethink our foundational normative commitments? Asking this question allows us to better understand cultural heritage law, our own commitment thereto, and the direction in which we may want to steer the field as emerging scholarship and scholars enter it. It is a difficult conversation, but one that I think is worth having as we decide how to use our current momentum. The question is also useful to me because it encapsulates the three themes of the talk: support, renewal, and iconoclasm. And I want to free us from the reverence we feel towards those who have been in the field longer than we have, particularly so we can free ourselves to imagine iconoclasm. The important thing for us to bear in mind is that the respect we owe each other is to our shared goal, not to our individual egos. As we stand on the shoulders of giants, we can do any of those three things: support, renewal, or iconoclasm. Our responsibility, after all, is to the field, not to the giants. As indebted I am to the giants, the reason I'm indebted is because they allowed me to perhaps see further. And it may be that the new horizon necessitates for us to achieve our shared goals as a field, doing something else than what the giants do, like correcting course before we get too close to a cliff we can now see. I'll stop belaboring this metaphor, I promise. But instead, let me get on with the work that I promised to do here. Now, onto the conceptual pillars. The way I see it, there are four conceptual pillars and assumptions in cultural heritage law, both domestic and international, with which I would like to take issue today. I chose these four because they are pervasive and they do important work today in the field. Most of them are also deeply ingrained in our historical thinking about heritage law. In the history of international heritage law, of course, one cannot forget the influence of colonialism in shaping and normalizing certain legal design choices. This theme, because of its importance, will cut across all the four concepts that I want to discuss with you today. Now, those four key concepts of cultural heritage law that I want to discuss are: first, the assumption of heritage's inherent value; secondly, the pillar of authenticity; third, the assumption that human rights can work as a panacea for the renewal of the field; and fourth, the pillar of expertise, or our field's trust in expertise. So let me turn to each in turn. But before I do that, just a quick caveat. As we think about each of these pillars and assumptions, to understand the work that they do today, we need to understand the historical, political, and theoretical contingencies that underpin their rise. Once we do that, we're better equipped to see that the work that they do is not essential, nor is it to be assumed. It is rather a political choice we make to accept, reinforce, or challenge these ideas. Now, first, on our assumption of heritage's inherent value. The idea that heritage has inherent value is certainly not new or unique. In fact, it is so deeply ingrained in our commitment to or investment in cultural heritage that we do not often stop to examine it. it means in short that there's something about heritage that gives it value that belongs uniquely to heritage, is created by the heritage itself, and can only exist within the heritage. This inherent value is what prompts us to think of heritage as irreplaceable, as existing for its own sake, as almost having dignity, to borrow from the Kantian imperative. It is unclear where this notion of inherent value in relation to heritage came from. It seems to have been around for at least since the 19th century, and early accounts of the history of heritage protection focus on the 19th century as a point in which our concerns for heritage safeguarding galvanized into legal action. It may be at this point, from a legal perspective, that we came to understand heritage as having inherent value. If this history, which focuses admittedly on Western Europe and particularly the French Enlightenment, is true, then there are two key things driving this move towards inherent value. One is humanism and its accompanying secularism, and the other is the protection of elites and their identities in the face of calls for social reorganization. On the first, one of the things that the French Revolution and the Declaration on the Rights of Man and of the Citizen of 1789 called for was a separation between church and state. The reason for that call was to turn away from the manipulation of the masses by religious authorities to diminish the privileged role of the church in social and legal institutions, and to effectively replace organized religion with a secular philosophy based on the ideas of liberty, equality, and fraternity. The replacement of religion with humanist philosophy also tracks closely with the idea of the inherent rights of man and citizen, and one that attempts to reestablish social and cultural membership, not around religion as a cultural reality and mechanism of gathering, but instead the state as an institution that wanted to separate itself from the power of religion by taking its place in social and cultural life. To do so, the artistic achievements that largely derived from ongoing church patronage and that perform religious and educational functions via their display in churches and other religious spaces needed to have another reason for existing. If they were no longer relevant because they reflected and taught about religion and morality and social norms, then they needed to exist simply on the basis of their artistic merit, which was inherent to the artwork or monument. In other words, inherent value exists to try and occupy the vacuum left by expunging the educational and religious functions of cultural objects and monuments with, well, nothing at all. It was a fiction designed to make nothing into something that could restabilize the social fabric. The same mechanics operate in relation to the elite protective function of inherent value. After all, not all monuments and artworks were religious. A lot of them were already secular, and they primarily displayed the up until then ruling aristocracy imposing their ways of life and preferences onto society as a whole via their portraits, landscape choices, and social scenes. Even when other subjects were included in the relevant artworks, they were still commissioned by elites, so they represented an elitist gaze and worldview. As these elites lost their property, and in some cases their heads, during the French Revolution, their artworks, for what they were and represented, also came under attack. If one thought of them as representing a certain elitist view of the world that the French Revolution sought to displace and replace, then they needed to go. On the other hand, if there were some redeeming quality to them that divorced these artworks from the context of their production, they could stay. So they were given inherent value as a means to salvage them. Of course, then the consequence is that we continue to elevate and praise aristocrats and aristocratic ways of life, reinforcing them as the pinnacle of human aspirations and achievement. We told ourselves that we separated those lives from the objects, but we kept on gazing at the lives as something that merited respect and protection. More contemporarily, the idea of inherent value is deeply intertwined with what Walter Benjamin described as the aura of the art object, a concept of which he was incredibly critical in his work on aura and authenticity, and to which I return below. Now, or later, rather. For now, this historical example of the French Revolution had ripple effects elsewhere, of course. It has justified dispossession, it has enabled racism. Particularly during colonialism, for instance, European colonizers arrived to the Kingdom of Benin, largely containing today's Nigeria. And when they arrived, they were so astonished by the inherent artistic value of the Benin bronzes that they disconnected from the historical fact of their production as the achievements of the local people. Instead, they thought that those bronzes were so sophisticated that they surely meant that Europeans had been to Benin before those specific colonizers had made it there, and taught the primitive locals how to make those beautiful sculptures. And because they were masterpieces of art with inherent value, divorced from the local society, they could, nay, they should, be taken to Europe to be displayed as part of a collection of the masterpieces of artistic achievement of humanity. And by humanity, we read, of course, the civilized Western European humanity. What this anecdote shows is that inherent value serves to divorce the heritage from its creators. It works well to connect heritage to all of humanity, as long as this humanity works towards or represents the stabilization of a status quo where elites get to spell out what culture is, how it is appreciated, and its value. Don't get me wrong, stabilization of political volatility is useful, and the instinct to insulate heritage from the same political volatility is very understandable and in some ways noble. Otherwise, purges would happen every time there was a major social change, and we would always be burning books and artworks, Nazi style. But the separation between heritage and its social and political context that inherent value produces is only useful as a temporary measure. Otherwise, it is more often than not co-opted by elites to promote elite ideas and power relationships. Thinking of a contemporary example, imagine the ongoing dispute around the Parthenon marbles. And it's crazy to say that the dispute is still contemporary. But among the ethical arguments that the British Museum advances to not return the marbles to Greece is the idea that the inherent value of these marbles means that they belong to all of humanity and that are not just the product of and part of the identity of the Greek nation. So in a way, inherent value does similar work to the idea of cosmopolitan heritage, which is important to live up to the UNESCO Constitution's promise of peace through cultural understanding and cooperation. But it also means that whoever gets to wave that flag, and that is often richer cultural brokers in rich nations, gets to effectively control it. And perhaps most crucially, inherent value makes us turn away from the ways in which people relate to their own culture and gives us the legal tools to actually demonize those practices and separate people from their own culture. Once we do that, cultural creators and stewards will be less invested in safeguarding a culture with which they can no longer use in their own terms, and we end up spelling the doom of cultural heritage, or at least its vibrancy, by separating the heritage from what made it vibrant in the first place. Now, a contemporary example is the dynamics of heritage law is that of the economics of heritage. We tend to think of heritage as being hors commerce, or outside the stream of trade. In accepting this idea that heritage will somehow be sullied by its trade, heritage law treats economics as either unlawful or just overall a threat to heritage. We then create disincentives for people to use and maintain alive their own cultures because it becomes something extra and separate from them pursuing their own livelihoods. We also then get to the point where only those who can afford the time to focus on culture, which is economic elites, get to produce it. So we perpetuate this idea of the world's cultural treasures being seen by a system of cultural patronage that focuses primarily on the elite gaze. Being more critically aware of these dynamics helps us understand that heritage has no inherent value. It serves a social function, which is necessarily attached to other aspects of social life. To separate heritage from its social function is to spell out its doom. Or at least to allow heritage to be co-opted to promote a very specific social status quo. That the law allows for that to happen is a great example of the law being made largely by and for the benefit of white, cis, able-bodied, straight, property-owning men. We allow culture not to be a spring well of social justice and reinvention, but rather a means of conformity to injustice. Culture is about the fringe, questioning society and the social order. We accept that to be the case with art, but somehow reject that the same should be the case with heritage. This conceptual incongruity that we are so accustomed to must go. Second, let me turn to the pillar of authenticity. Now, authenticity is the idea that we need to be able to verify where heritage came from so we can truly appreciate its value and worth. This idea comes from the art world primarily, and the notion that cultural objects as non-fungibles, that is, one of a kind, need to have their own non-fungibility ascertained so that we can properly value them in the market. It spills onto cultural heritage because cultural heritage, at least in its origins, seems to be simply old and nationalism serving art. The legal origins of authenticity from a Western perspective go further back than inherent value. They go back at least to the Middle Ages, but possibly before. A Christianity-centric account would suggest that authenticity came from the need to verify relics and their worth as they traveled throughout Europe as a means to validate and expand Christendom itself. To have a sacred object in a parish meant some mystical power and drew people into the new faith. Because the origins of Christendom are in the Middle East, these objects needed to at least initially travel from there, but one needed to be able to ascertain that a fragment of the Holy Cross was just that, rather than a piece of wood someone picked up just outside the door. So in some ways, authenticity goes hand in hand with justifying and enabling the expansion of ideas, authority figures, and institutions in an empire. Another historical example of the use and importance of authenticity goes back to Walter Benjamin, which I mentioned before. In his work on the work of art in an age of mechanical reproducibility of 1936, Walter Benjamin engaged with the idea of authentic works of art and the aura that they contained. That's an idea that has maintained a long and powerful grip on the imaginaries of how we conceive of and regulate heritage. Culture and heritage within it is at its best when it has this aura, which is a version of intrinsic value, and the authenticity that comes with it. What most people who still use Benjamin and aura to justify heritage safeguarding forget, however, is how critical Benjamin was of this concept. Specifically, Benjamin thought that aura and authenticity led to the disconnection between culture and the context in which it arose. It led to elitist numbness and manipulation, and in many ways enabled fascism, in his view. In other words, authenticity has the effect of separating culture from politics in potentially very counterproductive ways. Other, more contemporary examples of authenticity at work relate to a painting attributed to Leonardo da Vinci, Salvator Mundi, and the destruction of the World Heritage Site of Timbuktu during the civil war in Mali. Salvator Mundi is a painting attributed to Leonardo da Vinci and hailed as the ultimate lost and found story. Right? It went to auction and fetched an astonishing $350 million US. And then its authenticity, already confirmed by some experts, was disputed by others, and now the painting is no longer considered to be a quote-unquote genuine Da Vinci. Its valuation plummeted, and people are less interested in seeing it. And then there's Timbuktu, historically an epicenter of Islamic scholarship and worship in Africa. During the civil war in Mali in the 2010s, Timbuktu came under attack by a radical Islamic faction, and it was destroyed. World Heritage rules require that a cultural site, for inscription on the World Heritage List and for it to have outstanding universal value, be authentic. After destruction, the local residents rebuilt many of the 11th century mausoleums. Were they still authentic? And what does this possible loss of authenticity mean? These examples showcase the work of authenticity as a value-creating, gatekeeping conceptual pillar. It allows experts to determine whether a cultural object or site has value, with some absurd market incentives at play, which we can discuss later if you're interested. And it is these experts and not the communities that create the heritage that get to determine whether culture is worthwhile, whether it receives resources for its safeguarding, and whether it is worth seeing, visiting, or appreciating. The law has largely enabled authenticity and its reign. Normally, lawyers and legal institutions are very deferential to art and heritage experts in these matters. The law is preoccupied with authenticity, but it dares not question the work that it does and whether it's just work, whether it is just work. It simply assumes that justice will derive from upholding and reinforcing authenticity over and over again. I have written about and critiqued authenticity more extensively elsewhere. I'm happy to direct you to that piece if you're interested in my rantings on it, if you like. But for now, the key message is that the law plays a key role in shoring up this pillar, but we need not take it for granted. Authenticity can play a similar elite protecting role to inherent value. In fact, as Walter Benjamin in the 1930s, and even my description of the concept today shows, they often go hand in hand. But we must not allow our own ghosts to separate heritage from the people who, on justice grounds, we have vowed to defend. Now, thirdly, on the use of human rights as a panacea for the renewal of cultural heritage law. Human rights are the bread and butter of a justice-oriented legal order, particularly international legal order. They're also at the core of humanism as a belief and morality system that has, since the French Revolutions, 1789 Declaration on the Rights of Man and of the Citizen I mentioned before, sought to replace organized religion as a key organizing backbone for social relations. In the context of cultural heritage safeguarding, human rights plays an integral role to the extent that we recognize the right to participate in cultural life and the rights of minorities to their own cultures. For our purposes today, I want to focus on the right to culture as a relatively contemporary 20th century United Nations era phenomenon. From a legalistic perspective, the idea of connecting human rights to culture stems from instruments like the Universal Declaration of Human Rights and the two covenants, the International Covenant on Civil and Political Rights, Article 27 on minorities, and International Covenant on Economic, Social, and Cultural Rights, Article 15 on cultural rights. But of course, this idea that human rights and culture intertwine is not obvious or settled. From the origins of 20th century human rights movements to today, there have been those who query human rights and its attempt to replace religion as an organizing set of practices and institutions as an imperial imposition, partly because human rights seeks to displace the religious monopoly of local elites like it did in the French Revolution. There are also those who see in human rights a pathway to protection against and emancipation from harmful cultural practices. The debate between cultural universalism and relativism in human rights goes back at least to the 1940s, when the Universal Declaration was being drafted. There, cultural heritage as a physical marker of culture was not often at stake, but cultural practices we may describe today as intangible cultural heritage were very much at the forefront. Anthropologists decried the imposition of human rights and its calls for universalism on cultures which they sought to appreciate in their differences, whereas human rights sought to find commonalities. Never mind that anthropology itself, as a discipline, has very often been charged with the same imperialism from which they sought to protect peoples outside the North Atlantic. They now saw human rights as an ideology rather than the empire that facilitated their fieldwork as the problem. Over time, even anthropologists have come around to embracing the idea of human rights, and human rights became universally hailed as a language of emancipation and empowerment, to use a favorite liberal trope. And it certainly has those effects. But human rights can also judge and flatten culture. And most importantly, it will not necessarily do everything we promise it can do. Let us look at indigenous rights, for instance. The United Nations Declaration on the Rights of Indigenous Peoples of 2007 and the American Declaration on the Rights of Indigenous Peoples of 2016 both have a number of provisions specifically dedicated to indigenous heritage and culture. In fact, as scholars like Karen Engel have persuasively shown, culture is the backbone of all indigenous rights, for better or worse. These provisions on heritage in both these instruments recognize that indigenous peoples have the right to access and benefit from their own heritage, and loftily declare such. But they fall short of creating effective remedies for which these rights can be exercised. Now, let me be clear. International human rights law is terrific in many ways. and it's a great aid to how we think about cultural heritage and the power within it. International human rights law, in the context of heritage, forces us to think outside of heritage as a static thing with inherent value, and to think of heritage as something that matters because it is important to human beings, and at the very least, their identities. But human rights cannot always deliver on everything we want from heritage. The excessive focus on declaratory rights over remedies, for instance, exemplifies that limitation. Further, human rights requires individualization, which does not always sit well with culture as a collective endeavor. And finally, the human right to culture is relatively weak, left at the mercy of subsidiarity and the nation state's own description of what culture is and who it serves. Therefore, the emancipatory potentials or the emancipatory promise of human rights, particularly international human rights, as a pathway against the state when the state fails, is undercut in the context of culture. Human rights law as a language of power that transcends religion and its elitism. It is also, in its legalistic version, relatively open to being used by vulnerable groups. In fact, that's precisely its objective. But the same legal mechanisms that promote emancipation in the name of legitimacy and the voluntary cooperation of the states that claim to be bound to them tends to sacrifice culture as too diffuse, individualize the collective, and defer to state sovereignty and subsidiarity, particularly against historically disadvantaged groups like minorities and indigenous peoples. These groups, lacking resources to go against the state in other fora, the human right to culture ends up serving the same nationalistic and disciplining narratives that the idea of human rights was meant to undermine in favor of universal humanism. So regardless of our rejection of human rights in the name of relativism, or our embrace being undercut by legal mechanisms engaging poorly with the ideas of culture, identity, and heritage, human rights is not the solution to all problems. It does important work in humanizing the stakes of cultural heritage discursively, but its legal mechanisms are weaker than we like to acknowledge. Being critically aware of these shortcomings does not necessarily mean that we should give up on rights. Rather, it means that we need to be more mindful of where strategic and tactical possibilities lie, instead of putting all our proverbial eggs in the humanist or human rights basket. The fourth key idea I want to introduce today is cultural heritage law's reliance on expertise and expert pool. What this notion means is that much like in other areas of law and governance, we depend on experts to tell us what things mean, how to value them, and what we value them for. So we end up in a system in which it is not the culture creators, but the outsiders who make themselves experts on that culture as consumers, some of which can be creators, but their creator credentials are seldom why they become experts or why they're deemed experts. They get to decide whether something is heritage, how it is safeguarded, and for what purposes it is safeguarded. This notion of expert rule is prevalent most firmly in international heritage law. But because international heritage law trickles down to domestic practices very effectively, it is worth considering it in general. In international heritage law, the origins of this practice lie with UNESCO and the Cold War. When UNESCO was first created and started working towards implementing its culture mandate, the voices in the conversation were local craftspeople associations and mayors around many parts of the world, even if admittedly mostly in Europe. But then, as UNESCO initiatives turned to standard setting, experts took control. Why is that? One explanation, and the one I'm using for today's purposes, is that the reliance on local craftspeople associations and other mayors was seen as two things. First, too granular and difficult to generalize, and second, too political. On granularity and difficulty of generalization, the issue is that there was no common language that these organizations spoke. They also spoke to their own interests and did not purport to speak for the entire heritage domain wherever it existed around the world. So the lack of generalization made them too small, too niche, and therefore their voice is difficult to distill and easy to dismiss. Much like what happens in general when we talk about culture as a local concern, to be honest. And then on politics, the problem was that at about the same time UNESCO was starting to work, the Cold War kicked into gear. Then everything became polarized and paralyzed. It was impossible to create instruments, norms, and institutions if they were deemed to be political. They needed to appear as neutral, scientific, and apolitical. Enter the experts as scientists, and also, speaking to the first point, adapt at distilling local granularity into generalizations. Hence the rule of experts. Over time, every UNESCO treaty has deferred in one way or another to expert rule to tell us what heritage is, whether it is worth safeguarding, how to safeguard it. And we all just sort of all went along with it. And by being in this conference today, have ourselves on some level become experts on cultural heritage. On its face, there's nothing wrong with expertise. It is people invested in creating a common language of practice and undertaking said practice. And with the time and resources to do that, since it is literally their jobs. But the problem here is that over time and almost subconsciously, experts became increasingly self-referential. They stopped referring back to the communities that created or lived in, with, or around heritage. And they became extremely invested in protecting heritage against all threats, even the sources of the heritage itself. That is part of the reason why we end up with ideas like intrinsic value and authenticity. The problem here is that heritage divorced from people is dead and static. Also, over time, experts became so invested in the operation of heritage law that heritage law could not move forward without them. But also, experts were paid by states to make the system function. So we get to the point where experts are either working for the heritage, separated from the creators, or for the state that pays these experts, which in the case of minorities, often oppress these cultural creators and would rather have these cultures disappear in favor of a single or at least fully harmonized national narrative. And they do that instead of working for the people whose causes they should be representing. For instance, in the World Heritage System, nothing gets described, as I'm sure you know, unless at least 1 out of 3 expert NGOs that are mentioned in the text of the World Heritage Convention says that heritage should be listed as World Heritage. These experts were present when the convention was drafted, and now they're paid for by states to visit and assess potential World Heritage sites, or in the case of monitoring, existing ones. The livelihoods of those experts, not in all instances, but in many instances, quite literally depends on them being used by states. And we are supposed to believe that they're entirely independent and that there's no incentive for them to privilege a sanitized national narrative, for instance, over one that talks about minority resistance against the state in the World Heritage Site. Even if we do believe that to be the case, and almost everyone I've ever met, present company included, who does that kind of monitoring, is incredibly well-meaning and does the best to represent community views and to represent a view of heritage is not overtly nationalistic. There's still that subconscious incentive, right, to not piss off the state too much. And even so, even if we believe that to be the case, we're further asked to believe that in speaking for the heritage, these experts have a better sense of how that heritage has come about, what it means, and how it should be safeguarded than the local communities who created and have safeguarded that heritage for years, sometimes centuries. In other words, we have chosen privileged expertise over the local connections. We have done so, much like with other pillars and assumptions we discussed earlier today, as a means to separate heritage from distracting politics. But we did too good a job, and heritage lost its connection to the vibrancy and inherently political nature of our identities. We lost sight of the forest for the individual trees of the beautiful things we sought to safeguard. By protecting heritage from ourselves, we have also cut off the supply of life and cultural connection that makes heritage heritage, and that makes heritage valuable. Now, being critically aware of this shortcoming invites us to rethink more broadly why we are doing what we're doing and in whose name. As legal scholars trained to think about justice, we need to think of heritage justice as being social justice rather than elitist expert justice. Therefore, the archaeology of these pillars and assumptions calls for a more political engagement with heritage. To do so gets us reassessing what we take for granted and should never have. Why does heritage exist? Why is it valuable? For whom is it valuable? And what is our role in using the law as a language of power to channel the power of heritage and identity? Now, having the tools to now understand these ideas better, I wish to frame them in relation to some of the key challenges that lie ahead for cultural heritage law. These challenges range from disciplinary to global survival. They speak to the ways in which cultural heritage and the law accompanying it are products of and mirror society and its anxieties. Also importantly, because of cultural heritage's role in fostering and shaping social cohesion and resilience, the import of cultural heritage in response to these challenges cannot be underestimated. Therefore, as we think through these cliches, I wish us to try and see them afresh through the lenses of our commitment to cultural heritage as a field and as a cause, so we can peer into the stakes and the possibilities of action that are available to us. In relation to inherent value, I want to connect those issues with the Anthropocene. Human impacts on the world now amount to primal geological forces. And in this conversation, cultural heritage can play a key role in our preparedness and response to Anthropocene-related impacts on our lives. But doing so assumes thinking of heritage beyond intrinsic value. We cannot think of heritage just as something to be gazed at. It needs to be an integral part of how we live. We have done some work in this area already. The UNESCO Intangible Heritage Convention's operational directives, for instance, acknowledge the role of heritage in responses to disasters. But our actions are still to catch up, since everything that is listed as heritage related to disasters in the Intangible Heritage Convention's lists is more for gazing than for actually helping us respond to disasters. Heritage is only worth the name if it helps us be a better society in the future. Let us make sure that our work as heritage lawyers pushes towards that view. On authenticity, the biggest lesson here is one about the value of interdisciplinarity. As I mentioned earlier, the law tends to more often than not endorse our reliance on authenticity as a key maker of the value of heritage. It does not query the work that authenticity does, however pernicious it is. If we open ourselves more to interdisciplinarity, we're better equipped to query the work that concepts like authenticity and many others do, because we will see them as an integral part of our arsenal rather than something we simply accept from elsewhere. On human rights, the potential and limitations of human rights become apparent as we respond to conflicts. New and ongoing conflicts increasingly target heritage. The language of human rights can remind us of the connection between heritage and identity, and the importance of heritage as therefore a site of social resistance, of continuity, and of renewal in the face of oppression. But it can also undercut heritage because human rights individualize issues and prioritize certain effects of conflict over the effects that conflict has on culture. Therefore, human rights are not a full response, but can get us to think about heritage in fuller human terms. Finally, and related to conflicts, the challenge of the enforcement of international heritage law in response to international crimes helps highlight the stakes of our reliance on expertise, and perhaps even break away partly from our dependence on it. The International Criminal Court's response to the destruction of Timbuktu, for instance, is a terrific example of how enforcing international heritage law through international criminal institutions forced us to reconsider our reliance on experts. Even though the International Criminal Court ultimately did rely very heavily on experts, it also reminded us that heritage exists and is relevant because of its life within a community. And that it is okay for a community to reconstruct their own heritage, even if some experts will consider it to be no longer authentic. It is the connection the community experiences, rather than what an expert says, that matters in determining why heritage is worth safeguarding. Taken together, these four challenges, even if individually they're cliches, they remind us of the importance of rediscovering the political stakes of cultural heritage safeguarding. They also remind us of the possibilities of the law in rediscovering and redefining these stakes, and how the law should serve social justice via culture, and not use culture as a pawn for elitist conformity and oppression. The law matters most for those upon whom it bears harshly, and our commitment as heritage lawyers should also be a drive to wield the law as a tool of power in favor of a better future. Heritage is for the future, the society we want to be. So should heritage law. And now, therefore, in thinking about the three issues in the title of this lecture, support, renewal, and iconoclasm, what do I suggest happens to the four assumptions and pillars we have discussed? What's the call of this lecture? First of all, I wish us to support more interdisciplinary work because it will help us to keep the ever-changing stakes of heritage law and heritage safeguarding fresh in our minds as missions, commitments that we renew frequently, rather than assumptions we do not query. Second, I wish us to renew our use of human rights, our thinking about the possibilities of enforcement and how they can help us see the forest for the trees. There's potential there, even if not all wonderfully untethered from the pillars and assumptions we have discussed. But these are key tools for us to realize the possibilities of heritage, wielding the tools of the law at our disposal. But in order for this renewal to take place, some iconoclasm is due. I wish us to destroy the effigies of authenticity and inherent value, for us to realize that expertise is only relevant if it speaks for cultural creators, rather than for culture as a divorced trinket from the past. Interdisciplinary work can help us notice what these problems are. The legal tools I wish us to renew tell us how to deal with these problems. Iconoclasm gives us a pathway to the ultimate liberation and unburdens us to realize a mission of heritage law that is more in line with why heritage exists and why we care about it. Support, renewal, and iconoclasm. That is my call for action in what I see in the field of heritage law and what I would like to see in the field. It is how I wish to be made obsolete. It is what I invite you all to do. So thank you again for the invitation and for your attention. And I look forward to fighting with you until you no longer see any use for me.
Thank you very much, Lucas. And you know, even though it's time for morning tea, that we can't leave that. No, not at all. Leave that without opening the floor up to quick Q&A. And I hope you're okay about that, because there's just too many issues that have been raised there that I think that we should have at least 10 minutes Q&A before we have morning tea. So we'll start with participants in the room, and then if we can work it with the technology, we'll open it up to those that are joining us virtually. So I've got to say, I'm really tempted. There's so many parts of that I want to intervene on, but I'll start. I can't even imagine where. The issue even of iconoclasm, I've got to say, because of where that idea has come from and what it relates to in relation to heritage, and our French colleagues will talk about that as well, is that it's deeply disturbing that, the ideas of iconoclasm, and then to say that that's what you want, am I understanding that correctly, that you want to be promoting, I think is something that as people working in that field, that we know deeply what that means, because other people use that.
Yeah.
It is problematic. Yeah. Do you see what I'm saying?
Yeah,
I understand why you're trying to use that term, but if we follow it to its logical conclusion. Yeah, and if you think about, and we'll say Lemkin used it in relation to genocide, because that's how he brought the cultural elements in relation to genocide in, because he talked about iconoclasm when people want to destroy their cultural elements. Is that something that's the international law hasn't fully recognised that yet? And we know that that's one of the ways that it leads to the most devastating aspects of it. So is that the way you're using iconoclasm? And I think maybe not, but I don't want to put words in your mouth. And then I'll open the floor up to everybody else as well.
So thank you. So I'm definitely not thinking of the iconoclasm of heritage, but I do want to push for
that's what the term means, huh?
Yeah, exactly. Yeah. But I want to think of the iconoclasm of how we think about heritage, right? And that's why I kind of use that word, because it is very provocative, because it fights every instinct we have, right? As heritage lawyers, we're here for safeguarding, we're here for preservation, which has some problematic politics as a term as well. And then to think of iconoclasm, so I don't mean it as an iconoclasm of heritage, but I use that word on purpose because of its jolting kind of effect. Because I want us to sit up and not be complacent about our commitment to preservation, because our commitment to preservation is tied to certain ideas that, in my view, no longer do the positive work they were once meant to do.
Even that statement, we could open that up to the floor, even the preservation, because we had colleagues from First Nations speaking here today, because they would probably resist that as well. So I'll open and again, thank you, Lucas, because there are so many issues. Does anyone else have any questions for Lucas? Clementine.
Please.
Oh, and then we'll go around. Okay, I'll go around the tour, the table. The Clementine, then Limay.
Thank you very much. Well, we will have to discuss afterwards because then it's on Latin, ultimately. And I agree on almost all your conclusions. Just I just want to raise some point of concern about the question of interdisciplinarity, because you've been addressing the question of the role of experts, and I agree to a certain extent that it can be, let's say, a danger. But if we go towards interdisciplinarity, this means also maybe going towards some kind of experts. So maybe we're not talking about the same kind of experts, because there are the experts which helps us deciding, helps the states deciding or an IO deciding, and those who would be, let's say, counselors for us as researchers. So what kind of expert are we talking about, and what kind of interdisciplinarity are we talking about? Because if we as scholars go towards other disciplines, this is a point at some point. But then what can we do with that? Because this means that we need anyway some kind of knowledge that we're not able to get. So I think the line is not easy.
Yeah. It absolutely is a really complicated line, right? And I tend to go really hard on experts. But there are ways of engaging with expertise, right? There's the way we currently tend to engage with expertise, and again, this is a broad generalization, but it's a rather deferential kind of engagement, right? The experts understand something I don't, so I'm just going to take what they tell me for granted. But then there's also a more suspicious engagement, interdisciplinary engagement, which is one that doesn't fully do away with the questions we more naturally ask about power and who wins and who loses than a lot of experts in the field of heritage, right? And even among experts, right? And Ben is a terrific example of an expert that challenges a lot of the assumptions in the field, right? I remember, I don't know if I'm allowed to say this, but we're among friends, so nobody spread this. But I remember talking to Ben years ago about a lot of his work with IUCN and how he helped pioneer IUCN actually in assessing natural sites, actually stopping and asking the community, right? Even though it was not at all within their mandate or within their purview, but kind of breaking that fourth wall, as it were, of heritage value assessment to actually ask the community, so what do you want from this listing, right? And how do you go about safeguarding heritage? And let us enable that instead of our own preconceived views of environmental conservation, right? And so there is a lot of great expertise to rely on, but it's one that, again, to go back to the initial point, my problem with interdisciplinarity is when it's differential interdisciplinarity, right? Which is what we tend to do when we are afraid of the other discipline, right? So if you go deeper, we become more comfortable in mixing our own assumptions with the knowledge it brings to the table. So we become a dual expert as opposed to a single expert. And I think that there's potential in that, but there's always going to be that lingering risk of, we just become the problem. Yeah.
I've got to say, it's probably unusual, but in Anglo-Saxon countries, particularly in England and Australia, lawyers can't train just with a law degree. So we mostly now, you have to have another degree. So it is unusual for people to have this understanding of, you know, other disciplines.
I think this is a good point.
Yeah.
It's great.
Yeah, otherwise it's very
Openness.
narrow. Yeah.
Yeah.
So this is why for us it isn't that unusual. Yeah, but you tend to, the more you practice law, the more you forget about what you learned before, right?
Here we're talking about experts of other disciplines,
Yeah.
for scholars, for decision makers.
Yeah.
Something.
Li Mei and then Ben.
I'm maybe adding a little bit to the question I wanted to ask, but I just, with my interest in migrant communities, and because Anna mentioned Indigenous interests, I just wonder whether maybe there'd be a space for a new model of expertise that took into account better. And in my litigation experience, I often get frustrated where I have a planning expert or heritage expert who has very little understanding of my community's issues, as in the Chinese Australian community, and I feel like I have to spend quite some time in barristers' chambers preparing, like educating the expert about the about our so that they understand our community's concerns and how certain aspects of development, if it's a Chinese Buddhist development, actually operate, because they have no understanding of that. But I'll put that to one side. My question was actually about the points you made about authenticity. I wondered if you had any comments, again, in regards to migrant communities, about the idea of authenticity. And I guess I ask this because it seems to me, and I'm still very early in my HDR research here at UTS, that authenticity creates barriers in some way to particular levels of migrant heritage. For example, one of my teachers of my own community culture is my father, who's a community leader in the Chinese Buddhist community. But he's often got these ideas of what our culture's heritage is, because we're overseas Chinese, that are based on what things are like in China, like the Great Wall, the Summer Palace. And we don't have things like that here. So recently, on one occasion, I took my parents out to the Camden Museum, and they have a section on local Chinese community in the museum there. And one of the examples of local Chinese heritage was a piece of embroidery. And my father looked at this piece of embroidery and he said, "Oh, that's a terrible piece of embroidery. My sister could do something better than that." And I was, because one of the members of the local historical society was actually taking his time to show us and point out all the different objects. He was clearly quite proud that the community had something like that. And I was so embarrassed, and I said to my father, "Well, you know, your sister's in Malaysia, we're Malaysian Chinese, she's not Australian, so it's not like the piece of embroidery could be, you know, of significance to this local community." So I just wondered if you had any comments in that regard.
I have many comments in that regard. Migrants get such a raw deal out of heritage, right? And heritage law in particular. Because heritage law has that underlying kind of history, which is kind of enshrined in a lot of the legal mechanisms, even if we don't necessarily notice it, of pushing forward a nationalist kind of conversation, right? It's heritage as an anchor of national identity, right? Then migrants tend to get written out of that because they are, well, first of all, they're not citizens at the beginning anyway, and that narrative kind of challenges the nation, right? Or it makes the nation different. So the nation of origin doesn't want to have anything to do with them because they left, and the nation that receives them doesn't want to have anything to do with them because they challenge the local national narrative. So the law tends to do that, and part of the mechanism is by things like authenticity, right? Saying it's not an authentic Australian culture. Maybe it's Australian Chinese, right? Maybe it's good enough for migrant culture, but it's never going to be real Australian. And so authenticity kind of serves as that gatekeeping version again, which is oddly enough more often than not determined from the outside. In particularly marginalized communities like migrants, then the mechanics sometimes shift a little bit, because then they're so disenfranchised that authenticity actually gets to be determined internally, right? Then it's things like your dad's comment, right? He thought he could be the gatekeeper of what was good enough embroidery, right? Even though I'm guessing he doesn't often pick up a needle himself. There you go.
But it's complex, because if we were to take a model of expertise that gives more recognition to leaders and the equivalent of Indigenous elders, for example, in migrant communities, they're the sorts of challenges that will need to be addressed. It is, often the community is not armed itself to understand what the issues are, but even some members of the community will say, well, authentic Chinese culture is by reference to back in China. It's not necessarily because they may not have the local connection here, or their immediate family may not to a particular area.
Yeah, look, and to my shame, I don't know enough about the cultural dynamics of Chinese Australians, but just to use a different diasporic example, Greek communities in central Canada, right, in Ontario, they're Greeker than the Greek, right? They fight harder to hang on to certain symbols of Greek identity. And in many ways, they are the ones who are primarily funding things like the litigation around the Parthenon marbles, right? It's the diasporic communities, it's not. Because the Greek government has been broke for, even though it has been a useful distraction by the Greek government, right? It has been an important political tool for them to distract from the crisis by saying, let's focus on the UK, and the UK as a prop for the union. But anyway, so there are those dynamics, and and what counts as the culture that the migrant community refers to. Countries like China and other countries, particularly in Asia, they do have a stronger attachment to the idea of authenticity, at least in heritage law, than other countries, especially when it comes to intangible heritage, where authenticity should never be at play. And yet somehow you look at Indian or Chinese domestic intangible heritage legislation, they're very firm on the idea that there is such a thing as judging intangible heritage to be authentic or not. So it is a complicated dynamics, again, of those assumptions we bring to the table of how we value our own culture, but we need to be mindful that in trying to hang on to how we value our culture, we're also gatekeeping it. And it can be very disruptive in migrant communities in particular.
Thank you.
This will have to be the final question, unfortunately. One final
Sorry,
question.
my answers are a bit long.
From
We've raised so many issues here that we could spend the whole day talking about it, which would be wonderful. But
Ben, that was the point. We are going to spend the whole day talking about it.
with many other filters. But this whole question of heritage justice and its link to social justice is fundamental, for example, to what is happening in Australia at the moment, from the message from the heart through to the referendum that we're going to have next year. And this brings us to the question of who do you ask? Who are the experts? I mean, on the one hand, the IACN is sometimes ignored by the World Heritage Committee, but on the other hand, we ignore the people whose heritage we would hope to regard it is. So the question here, in terms of the message from the whole Uluru Statement, is in fact this question of the social justice aspects of what our heritage is as Indigenous people. I'm talking here then in terms of First Nations people, but also the heritage of people in Australia as a whole who have inherited that. There are so many questions here, but that link between heritage and human rights is not necessarily obvious to many people. It's not obvious to heritage lawyers and human rights lawyers, and this is where the value of your work comes in very much in the last few years, making that link and saying it's inherent. You can't talk about heritage without talking about human rights and justice.
Thank you.
I don't think that was a question.
Yeah.
Because I think that was a statement and a positive one about your work.
So that's a lovely
Do you
note
want
to
to
end on.
respond to that?
No, because I think I'm just going to butcher that.
It's a hard. It's a hard. Look, are you happy?
Yeah, happy to.
Excellent. So, look, let me again thank Lucas for this wonderful, and people will say it, but this in this case is absolutely true, rich contribution to start off our proceedings today, where scholars, emerging scholars, are going to give us their work in progress. I'm sure that will trigger further questions and discussions in that context as well. So let me again invite you to thank Lucas Lazinski for his other. Now, I think Welcome back, everybody, for our first session this morning, still morning, just of the commencement of this doctoral colloquium. And again, thank you to Professor Lukas Lesinski for his opening talk, which we are deeply appreciative of. We have three panelist discussants or papers today, and our discussant, and I'm very grateful for Professor Pascal. And I apologise. I'm going to butcher your name, from Paris. No, he's kindly accepted the invitation to be the discussant. So we're very, very grateful for that. Just for the panelists, I think everybody is actually zooming in to present their papers today. It will be 15 minutes and you will receive a 2-minute warning prior to the end of your talk. Unfortunately, that will be broadcast to everybody, and also a 1-minute warning because of the time restrictions that we have, because we are running slightly behind schedule. So let me introduce the first panel speaker, Yasmina Azi from Toulouse. There is a colleague from Toulouse, Clementine, and she'll be delivering a paper entitled The Relations Between International Criminal Law and Cultural Heritage Law. Welcome, Yasmina.
Okay. Oh, hello.
Wonderful. We'll just try and get your visual up, Yasmina.
Okay.
And I know it's very, very early or late for you there. It's not a convenient time, so we're grateful.
Actually, it's late.
Sorry, Yasmina. But we're very grateful to have you participate. Go ahead.
Thank you for giving me this opportunity. I'm glad to be here.
Yasmina, do you need to share the screen?
Yes, I do. Can I do it now?
We're just organising that.
Okay, thank you.
You should be able to share your PowerPoint.
Okay. Yes.
She's sharing the PowerPoint. She hasn't. No, she doesn't have the. She doesn't have the camera.
Okay, can you see it?
Absolutely.
Okay,
Please
perfect. Okay, so hello everyone, and good morning then. And today I'm going to talk about the relations between international criminal justice and cultural heritage law. Based on the theory of the unity of international law by Mario Prost, I am going to talk about those relations. So I have two general hypotheses. I consider the strengthening ties between both those branches of international law as a sign of the unity of international law. And at the same time, I think that the increasing consideration of the cultural aspects of some international crimes is evidence of the link between the protection of cultural heritage and the prevention of war crimes and crimes against humanity. So today I'm going to try to answer to this question, the first one. How did cultural heritage law get incorporated into international criminal law? So basically what I say is that there is a reinforcement of the relation between cultural heritage law and international criminal law through institutional channels. So first of all, I have to clarify the subtle nuance between the words cooperation and collaboration. According to the online Cambridge dictionary, to cooperate means the act of working together with someone or doing what they ask you. Whereas to collaborate means the situation of two or more people working together to create or achieve the same thing. So the difference, I think, is in the purpose and the balance. To collaborate is to work to achieve the same goal. On an institutional level, I think that the clearest example of the evolution of the relations between cultural heritage law and the international criminal justice is the increasing closeness between UNESCO and the ICC. So first of all, I am going to talk about the role of UNESCO facing international destruction of cultural heritage. So I have identified two trends, similar in substance, but of different intensity, before and after 2017. So let's recall that the 1954 Convention on the Protection of Cultural Property in the event of armed conflict was drawn up under the auspices of UNESCO. This convention, which is in many ways the cornerstone of the protection of cultural heritage in times of armed conflict, is the first binding legal instrument that uses the term cultural property. And following this convention, UNESCO has continued to produce law applicable to cultural heritage also in times of peace. So this is the case, for instance, of the Convention on the Prevention of the Import and Export of Cultural Property of 1972, which aims to respond to the problem that arise in the period of peace or post-conflict. So in addition to this binding convention, UNESCO has issued declarations as regards to violence against cultural heritage. And for this presentation, I will limit myself to the review of the 2003 declaration concerning the international destruction of cultural heritage. That declaration was issued following the destruction by the Taliban of the giant Buddhas of Bamiyan and cultural property in museums in Kabul, Afghanistan. I believe that this declaration is in many ways the most visible and significant starting point of what I think to be a trend, the awareness of the real vulnerability of cultural heritage in times of armed conflict or occupation, and of the consequences of the destruction of such heritage. The declaration called for working toward a concerted application of existing and future instruments for the protection of cultural heritage. And I think that the UN Security Council resolution that have been adopted in the last 2 decades echo this declaration. So while this trend, which follows binding conventions and precedes the resolution 2347 may seem soft, I think that the issuance and the recurrence of those soft law instruments have in fact been the necessary precondition for the emergence of a more solid, general, and articulated legal framework. In fact, I think that they have facilitated an awareness that was necessary for the individual actions of states and international organizations on one hand, and the coordinated action of states and international organizations on the other hand. So about after 2017, I believe that the trigger for accelerating action and strengthening cooperation between international organizations was the resolution 2347. That resolution, which is considered by some historical, has, in my opinion, laid the foundation for a general framework for action and cooperation. It allows for the articulation of the action of member states and international organizations while enshrining the fundamental importance of the protection of cultural heritage in times of armed conflict and in the face of terrorist threats. So in order to optimize and harmonize efforts, the UN Security Council encourages all member states to ratify relevant international conventions. I quote, the harmonization of efforts to protect cultural heritage implies the harmonization of national legislation. So the ratification of and the implementation of the 1954 Convention is a minimum standard for the standardization of national regulations concerning the protection of cultural heritage in times of armed conflict. And in the same quest of harmonizing efforts, the resolution, I more or less quote, urges member states to develop broad law enforcement and judicial cooperation to prevent the trafficking of cultural property with the assistance of the UN Office on Drugs and Crimes in cooperation with UNESCO and Interpol. I think it is a call for cooperation between international organizations on the one hand and international organization and states on the other, as you can see in my illustration. So I think that this level of cooperation tends to be closer to collaboration insofar as all actors work together with the same objective. Moreover, I believe that the aspect of police and judicial cooperation, notably between UNESCO and Interpol, is a particularly significant indication of the emergence of a criminal aspect to cultural heritage law and a cultural heritage law aspect to criminal matters. So when it comes to UNESCO's role, UNESCO has a logistical support. The logistical importance of UNESCO in documenting the destruction of damage and of cultural heritage is underlined by the resolution in which states are encouraged to contribute to the strengthening of measures to protect cultural heritage. While UNESCO is centralizing efforts, it remains essential that states actively participate in the implementation of measures to protect cultural heritage, as this heritage is attached to their territories. So, as we can see in the first text in the slide, UNESCO logistical support depends on the financial contribution of member states, but the initiative to establish an emergency fund for cultural heritage finds an impulsion in UNESCO's normative and institutional activity. More recently, the draft policy and the policy established between UNESCO and the ICC highlights UNESCO's role in the process of judging the intentional destruction of cultural heritage. So here in the second text, it is the practical dimension that is at stake. The precise documentation of the cultural heritage is precious data that UNESCO is able to communicate. From a litigation perspective, this has a double advantage. On the one hand, the judge will be able to have at his disposal precise elements, allowing to evaluate with accuracy the extent of the damage caused. On the other hand, in terms of preparation, these factual elements and the expert data allow a more accurate evaluation of the funds and even the methods that will be necessary for the reconstruction or restoration of the damaged heritage. Plus, the symbolic dimension attached to the tangible cultural heritage targeted by a potential attack can also be taken into account in the judgment. So the evolution of international law and the recurrence of deliberate attacks on cultural heritage has led UNESCO to move closer to the ICC. And this alignment by UNESCO has been met by a parallel movement by the ICC, which consists in the implementation of policies in favor of the repression of crimes against culture and consequently, as well as, I think, the protection of cultural heritage. So what is about the ICC? So I think that the ICC has an increasing role into protecting cultural heritage. The ICC does not, in principle, have a particular role to play when it comes to the protection of tangible cultural heritage. However, I think that a dynamic reading of the preamble of the Rome Statute and the examination of a recent of the draft policy and of the policy on cultural heritage makes it possible to realize that the ICC is maybe more invested in the protection of cultural heritage than it seems to be. So the preamble of the statute of the Rome Statute, as you can see, states in the first paragraph that the state party are conscious that all people are united by common bonds. Expressly, the words common heritage and cultures appear in the preamble, and the inclusion in the very first lines of the preamble of elements relating to the cultures of the peoples of the world and to the fragile ties that bind them together leads me to believe that this is, to a certain extent, a reintegration of the cultural element into criminal matters. As we know, the drafters of the 1948 Convention on the Prevention and Punishment of Genocide had given up the possible cultural dimension of genocide. However, the inclusion of the words common heritage and cultures in the Rome Statute's preamble favors a dynamic reading of the other provisions of the statute, specifically through the interpretation in the light of context as understood by the Article 31, paragraph 2 of the Vienna Convention on the Law of Treaties. I believe that the presence of these elements in the preamble of the Rome Statute integrates the cultural matter into the criminal matter in international law. And in terms of legal potential, I think that a dynamic reading of this preamble can bring flexibility to the Article 8(2)(e)(4), which provides for the international destruction, the intentional destruction of cultural property. And as we know, this provision of the Rome Statute uses language that predates the 1954 Convention, which then I think freezes the intentional destruction of cultural property into the laws and customs of war from the last century. So I think that a reading of the provisions relating to the intentional destruction of cultural property in the light of the preamble is a good path for an updating of those provisions. So here in this text, we can see a shift. So a shift from cooperation to collaboration. Adopting a multidimensional approach means going even beyond the law and its unification. It also implies factual, logistical, and practical collaboration. In my opinion, this is the manifestation of the establishment of a kind of common legal policy that testifies to the reciprocal integration of the cultural legal matter with the criminal legal matter. In other words, I think it reflects the choice of a more holistic approach to that question. That is to erase or at least to attenuate the borders between legal disciplines. However, not between institutional competences, but those institutions continue to act within the limits of their power and competences granted to them by their constitutions. The draft policy and the policy outlines two areas that constitute the objective of the cooperation agreement between the ICC and UNESCO. So here you can see the two objectives. Specific elements deserve attention here. I think it is possible to classify them in two sets of complementary measures, some downstream and other upstream. For all of them, the objective remains the same. So downstream, we find, first of all, the impunity for the perpetrator of crimes against cultural property. I think that the fight against impunity of such crimes is an objective subsequent to the commission of such acts. Second, the draft policy also addresses the impact of attacks on cultural heritage, as you can see, including an intergenerational impact. I perceive two dimensions here in the sentence. One, on the one hand, the seriousness of crimes against culture can orient international criminal policies. And considering the repercussions of attacks on cultural heritage can reinforce the repressive scope of the provisions of the Rome Statute. On the other hand, considering the symbolic dimension of heritage and its importance for the reconstruction of a state after a conflict in the framework of a criminal judgment contributes to the realization and the process of resilience of the victims. I believe that criminal matters should not be detached from the human dimension that is intrinsic to them. the International Criminal Trial is an important step in the process of reconstruction of states and resilience and healing of the victims. Upstream, it is the logistical and coordination aspects of the action of the ICC and UNESCO that are at stake. I believe that this point, it points to an exchange and even maybe a mixing of the cultural and criminal spheres. By this, I do not mean an exchange or mixing of competences. It is the material substance, the cultural and criminal matters that tends to be to find a common ground of application. So
Yasmina, I will need you to wrap it up just so that the other speakers will have a chance to
okay, sorry,
and also to get feedback from Professor Bouvard.
Okay, I'm
I will by the end of today get it right, Pascal. Go ahead, Yasmin. If you could wrap it up in about a minute, that'd be great.
okay, of course. I'm about to finish anyway. So yeah, I think that there's matters of mutual interest that we understand broadly as crimes against culture testify to the emergence of a sphere of common sphere to both criminal and cultural matters. So finally, from what we can read here in the policy on cultural heritage, I personally have hope that those crimes will be more and more repressed and that the cultural heritage of peoples more and more protected. So, thank you.
Okay, thank you very much, Yasmina, for your very interesting communication. I think you have a very relevant topic and subject, and you can propose with this topic a very rich and innovative PhD. I would like just now first to know when did you start when did you start to prepare your PhD, and who is your supervisor?
Well, I started to officially I started to my PhD in 2021. And I have two supervisors. One is Clémentine Boris and Pierre Bosset from Université of Quebec in Montreal.
Okay, thank you. So I have several remarks on your presentation and on your PhD. The first one is the following. You start your presentation with an hypothesis. The relations between international criminal justice and cultural heritage law is a good example, or is an expression of the unity of international law. This is a very strong hypothesis for the beginning of your thesis. But perhaps at the end of your work, you will find that it is the contrary. The relations between international criminal justice and cultural heritage law is a good example of the diversity of international law, of the divisions of international law. And for me, it is not an hypothesis that you have to demonstrate. It's more a question, a general question, and you will see at the end what is the answer of this question. You don't think it will? What do you think about this remark?
So first of all, actually, this is not exactly the topic of my thesis. Let's say that this is like a part of the topic of my thesis. My thesis is way more, it's about the cultural heritage law and collective security. This is only a part. And about the hypothesis, well, for the moment, I base myself on Mario Prost's concept of unity, because I like the perception he gives about even the word unity. He understands that as a very moving unity, which means I'm not saying that it's international law is like a rock, a permanent rock. What I'm saying is that there are permanent interferences and permanent changing in international law. And sometimes some disciplines that we may see like pretty different are meeting together because there is an interest, there is a mutual interest. So that's what I think.
Because for me, I would have the different hypothesis. I would have the hypothesis of the chaotic international law more than the unity of the international law in this field, I think. But it's true that there is a movement of convergence. But I think for the moment it's not very very coherent.
I really understand what you mean, because I have a kind of perception that is like in physics, you know, and physics. So I understand.
Theory of the cow.
Yeah, exactly. But maybe this cow is a unity. And
okay.
it
You have a
probably
large
is.
approach of the unity.
Yeah, exactly. That's
chaotic
how
unity.
I see. There is, so that's how I perceive it. I don't think that if international law is fragmented, I ask what is between the fragments. So there is a substract. There is a you see what I mean. So this is very physics perception of international law, and that's how I perceive unity, a moving, permanent moving unity.
Okay. My second remark is the following. What is your conception of international criminal justice? What is for you the scope, the field of international criminal justice? Your work will be focused on the substantial criminal law, or will also deal with procedural criminal law? I understand that you will study in your paper the incriminations regarding cultural heritage, international law, and in the Statute of Rome of the International Criminal Court. But the main question in practice is more the question of cooperation between the states, and this question of international criminal cooperation for me is a strong question of international criminal justice. And do you think criminal cooperation is a part of your conception of international criminal justice?
Yes, I think so. Yes, because I consider, if I talked about international criminal justice and not about international criminal law, is because I perceive justice as being broader. I think that the judicial and the cooperation, even in the police level, is extremely important. Let's just think about the evidence of the crimes. It's not especially a matter of, it precedes the trial, right? So this is, if I talk about justice, it's because I wanted to use more elements, but from now I'm just at the beginning. But that's what I meant. I would use also procedural, yes, procedural law. Yeah.
So if you study international criminal cooperation, international judicial cooperation on cultural heritage, you will see that there is another question. It is the relations between the common rules on criminal cooperation and the special rules for the cooperation concerning cultural heritage. And I think there is also a question of relations between the general standards, and if we have to build for the future, and if it exists now, some special rules, and if we need special rules for the criminal cooperation concerning cultural heritage. Did you understand me?
Yes, I understand you. And actually, I was writing what you're saying because I find it extremely interesting, and I think I will need to take a look on it.
So I don't know if we can open the discussion with other
We might not be able to, but I'm going to monopolise as the chair to ask a question, or not so much ask a question, make an observation, because you may not be aware of some of the issue, what I'm about to say, because it's probably not documented in relation to the relationship between UNESCO and the ICC. I think at the moment it's very slanted towards what happened in Mali. And that Malian situation was very particular in that the government referred the matter to Mali, and then they allowed the ICC to use, including the ADG culture, to give expert evidence before the court. That is certainly not going to happen in the case of the Ukraine and the Russian conflict. Yeah, so, and I can tell you that UNESCO is not working in relation to that regard because of, and I think that will feed into your thing about permanent security, is the dynamics within the Security Council are also played out in relation to what you were talking about with UNESCO and the ICC. So again, you probably wouldn't be aware of that because it's unfolding, but be conscious of that, of the nature of the conflict that is involved and the particularities of when and how the ICC can get involved. Having said that, the previous chief prosecutor was very interventionist, as we know, and she was the one driving that, is Fatou Bensouda, yeah, rather than UNESCO. The other thing that I'd suggest before we move on to the next speaker, I'm sorry, but I'm just very conscious of the time, is please have a look at Dirk Moses's recent book around permanent security and genocide. He's a genocide scholar, but a lot of what he speaks about, and he reevaluates his scholarship in the field. Lucas was talking about iconoclasm. He literally undercuts all of his basically life's work in genocide, but and he gives a lot of documentary and theoretical arguments around it that might help your work as well as you're going through and finalising your doctorate. That might be of interest to you. So it's not directly relevant, but it might inform your writing in the field. So Dirk Moses' book, as I said, is really, really interesting. Does anyone have any points? Just again, being very conscious of the time. Does anyone like to provide any? Lucas? No? Okay. So thank you very, very much, Yasmina, for a wonderful way of opening up our conference today, because it's probably the hard end of cultural heritage law that we're looking at, or cultural heritage protection in international law. And again, a bit like the way that our conference started, we haven't done justice to the richness of your research that you're undertaking, and because of the time constraints that we have. So thank you very much for this wonderful this colloquium. Now the next speaker is Diego Machado, at the University of New South Wales, one of Lucas's PhD supervisees. He's presenting on the instrumentality of cultural heritage for international security and vice versa. Now, Diego, I would ask if you can to share your screen, and also the speakers could turn on their cameras, because it is a bit alienating in this room without seeing you. I mean, we want to, in this day and age, be ensure that there's proof of life, that we're speaking to a human being. And also, apologies to the speakers, but we do have those time warnings. As you say, I'll give some leeway because we'd also like to give you the opportunity to receive the wisdom of Pascal. So Diego, we're trying to fix that for you, Diego.
Yep, I'm just trying to, I can't see the function yet.
We're trying to fix that for you.
Just the same.
Maybe because it's not the right stage. No, it is.
What if you just promote him to co-host?
Diego, can you share now?
No, not yet. And I can't turn on my camera just the same.
It's the status application.
You should be able to share your screen, Diego, and I'll see if we can allow you. We may need to proceed for now without you being seen, unfortunately, and we'll continue to rectify that as you're speaking, Diego, if that's possible. Can you share your screen?
Yeah, no, I'm not able to share the screen.
Yasmina, it might be that Yasmina needs to stop sharing.
No, but I should stop, otherwise it will be showing.
Am I still sharing?
No,
Okay.
Maybe if I leave and come back? No.
Yeah, I think yes, could come back with a different status.
Okay, Diego, we'll swap the order if that's possible, and let's see if we can rectify the technical difficulties for you. If that works for you, is that okay?
Yeah. What do you want me to do? Sorry.
We'll move you to the next speaker, and we'll proceed with the other speaker on this panel, so that hopefully they won't have the same difficulties, and while we try and rectify the technical issues for you. Okay, I'll proceed to Da Hong Yu. Hong Yu, can you hear me?
Yes, but I
Wonderful. So
cannot take on. I cannot turn the camera. It's forbidden.
Because this is a webinar and not.
no, it's not a webinar.
No.
It is a webinar, sorry.
Yeah, so if he's not as a speaker, but he entered as a guest.
Have you entered as a guest or as? Please, all panelists need to enter as panelists. So the email that you received as panelists rather is registration.
Because otherwise
they know they're panelists. It's okay.
Oh, okay. So.
Okay. So if you could give us.
No, I don't have a link. Because, for example, in the chat, I can speak to the host and other speakers.
Yeah, but you can do that. Okay, can we'll if we can just have 5 minutes, we'll go on mute and we'll try and resolve the issue for you. Yeah, won't be long.
Okay.
You can.
it's a lot.
Done? Oh, it's
It looks like it's working.
It's starting.
He started screen sharing.
Good. It's okay. Great.
Now, lovely.
I think everybody in the room agrees with that sentiment, Diego. And we are now back in calm mode. Okay. Okay, Diego, I will open the floor to you, given that we've wasted a few minutes with that. If you could start, and again, apologies. You will get the time warnings, but I'll give you some flexibility given the issues around what's just happened. So, Diego, the floor is yours.
You may need to unmute yourself.
Oh,
again.
thank you very much. Well, unfortunately, I can't turn on my camera. Hopefully I can do that a bit.
Our technical expert.
But we could hear you. Okay.
All right. First I want to thank the organizer of Colloquium on new developments in international cultural heritage law, especially Professor Ana Filipa Vertoliag, Pascal Beauvais, and Lucas Jasinski for this kind invitation to talk about the instrumentality of cultural heritage for international security and vice versa. I will start by talking why I am interested in this topic. Before researching about it, I worked in the Brazilian government in partnership with these international organizations on international cooperation in criminal matters. So I was basically using the legal framework that they provide to request and provide international assistance to cooperate with countries in investigations regarding drug trafficking, transnational organized crime, corruption, money laundering, and terrorism, for example. I found it so interesting that I got back to university to research the intersections between transnational crimes and cultural heritage, which is about what I'm going to be speaking about today, with a focus on terrorism and terrorism financing. And here is why I think you should be interested in this topic as well. Cultural security is a very interesting emerging discipline that speaks about the significance of heritage in international affairs and how it is changing from cultural diplomacy to international security. So I take the counterterrorism regulation of cultural heritage as an example to analyze the overlapping of international legal regimes. And I do that to explore the challenges and possibilities that arise when two legal regimes overlap. So what I'm going to do here today is analyze the legal framework of these two regimes, cultural heritage on one side and counterterrorism on the other side. What kind of international legal instruments they rely on and consequences regarding the enforcement potential, for example. I also analyze the actors who build and implement these international legal instruments and mainly their purpose, because my crucial point here and my argument is that this legal framework, the counterterrorism regulation of cultural heritage, must serve both international security and cultural heritage priorities to achieve sustainable peace, and not the purpose of only one of those regimes. I'll start with the resolutions of the UN Security Council. They are basically the main instrument of international law, clearly associating cultural property with terrorism risks. In 2015, the Security Council condemned the destruction of cultural heritage by terrorist groups and noted with concern that terrorists were generating income from looting and smuggling cultural items. These two concerns here, they are important in the sense that I'm going to be speaking here about terrorism, which relates mostly to the destruction of cultural heritage for propaganda value, for example. But I'm also going to be speaking about terrorism financing, which relates more to the concern of terrorists generating income.
Diego, we've lost your audio. Can you, it might be just some
It may be
connection.
losing us.
Diego, can you could send a message to Diego. Diego, we've lost your audio.
Okay, we can just drop it.
Okay. Diego, if you can try and log on in the next minute, otherwise we may need to move to the next speaker.
It's not me.
Diego,
I sent him a text, but
Oh,
maybe we
good.
should go forward.
yeah, I'd just like to give him maybe a minute just to,
Yeah,
just because otherwise just it chops in, it's not fair to him, just because of the technological issues.
Okay, he's reconnecting.
Can you hear me?
There you
Yeah,
go.
we can hear you now.
Oh, I'm sorry. I'm sorry for
No,
that.
no, it's, believe me, I think we've all been there 1,000 times in the last 3 years. So, and then some. Okay, so Diego, please proceed.
All right. Thank you very much. And I'm sorry for that. Yeah, and 2 years later, Yasmina spoke about this resolution as well, so I won't take too long here. The Security Council enacted a resolution on the destruction and trafficking of cultural heritage by terrorist groups. Having a resolution exclusively about antiquities trafficking and terrorism is already telling of how cultural heritage matters for international security. But the text of the resolution makes it very clear as well by highlighting the importance of cultural heritage to security, stability, and governance. So the Security Council clearly makes cultural heritage a matter of international security. Here you have a visual example of why the Security Council is concerned. It's about the looting of this archaeological site in Syria during a period of less than 1 year. These pictures informed news about ISIS cashing in on looted antiquities to fuel Iraq insurgency. And basically we had people digging the ground, taking artifacts and trading them to raise money to finance terrorist activities. Regarding the legal framework of these two regimes, when you speak about the counterterrorism regime, we have mostly resolutions of the UN Security Council, the ones that we spoke about. We have recommendations of the FATF and international conventions. While when we look at the cultural heritage regime, we have mostly international conventions. And as we know, the adoption of an international convention takes a lengthy and thoughtful process of negotiation. But when adopted, they are hardly amended. So they are indeed a rigid legal framework, especially if compared to the resolutions and recommendations of the FATF, which are mostly circumstantial. I mean, they aim to timely respond to current international security threats, as we saw for the UN Security Council resolutions enacted in 2015 and 2017. And the same applies for the recommendations of the FATF. For people who are not familiar with this intergovernmental international body, it is made of, it's basically a group of the 37 richest countries in the world who have recommendations against money laundering. At first in the 90s, after 9/11, they issued recommendations against terrorism financing. And after 2012, against weapons of mass destruction. So we can see that they are adapting their recommendations to what is taken as international security threats. So they're basically circumstantial as well. The consequence of that is that when you have more circumstantial legal instruments, they are more likely to clearly associate cultural property to terrorism risks, while if you try to address the problem from the cultural heritage perspective, it's an association that is more indirect. You would have to do that taking a look at the 1970 Convention Against Antiquities Trafficking, for example, or the Convention for the Protection of Cultural Heritage in Armed Conflicts, the one of 1954. Another very important difference here between legal regimes, the legal framework as well, regards the enforcement potential. The UN Security Council resolution of 2015 that I spoke about, it acts under Chapter 7 of the UN Charter. So it's mandatory for every country. And the recommendations of the FATF just the same. Literally every country in the world is assessed about their capacity to implement the resolutions. And after the assessment, the country is classified as compliant and non-compliant. And if it's classified as non-compliant, the FATF applies sanctions more or less like the ones that Russia is suffering now. So you basically apply financial sanctions aiming to isolate a country to achieve a particular purpose. In the case of Russia, of course, is to stop the war. In the case of the FATF, is to make the country comply with the recommendations. While if you take a look at the cultural heritage regime, it's basically made of international conventions, and we know that states voluntarily agree to be a party or not to a convention, and the regime tends to lack teeth.
You could let him know. Okay. You could let him know if you can log in a minute and then make.
This is so terrible. I'm sorry.
No, again, no. We completely understand.
I'm relying on my data here, like rather than Wi-Fi. Anyways, I hope it will. So security priorities tend to be foregrounded when the two regimes overlap. Regarding the actors, the main thing here is that the cultural heritage regime establishes obligations for states to refrain from destroying and damaging cultural heritage during conflicts. And this state-centric approach hampers the UNESCO capacity to deal with stateless entities like terrorist groups, for example. While when you take a look at the counterterrorism regime, the Security Council has consolidated lists that includes individuals and entities subject to sanctions. So you really get to individuals, to like people, either natural or legal people. And when people and entities are included in these lists, countries act to freeze and seize their assets. So, for example, if some of them are found with a cultural object in their possession, in theory, this cultural object is forfeited and then, of course, recovered. And this takes me to the purpose of these regimes, which is like the main point of my argument here. Of course, for the counterterrorism regime, the purpose is to address terrorism risks. And they do that acting on the assets, right? If you're speaking about terrorism and terrorism financing, which is basically where cultural heritage intersects with the counterterrorism regime, they might recover a cultural object, but they do that basically for punishment and for cutting the funds that support the terrorist activities. Yesterday at the conference, we had a session on cultural heritage, sustainability, and peace. And one of the targets of the Sustainable Development Goal 16, for example, explains very well this rationale of how regimes on transnational crimes address, like combat crimes by trying to forfeit assets, right? The target aims to reduce illicit financial and arms flow, strengthen the recovery and return of stolen assets, and combat all forms of organized crime. So for that perspective, forfeiting is enough, right? If you forfeit the asset, you punish the criminals and you cut the funds. But if you look to this matter from the cultural heritage perspective, it's not only about recovering the cultural object, but it's mostly about how you're going to manage the recovered object. Because as a way to achieve a sustainable peace, which is basically the Sustainable Development Goal 16, You have to manage heritage in a way that it contributes to shaping communal narratives, spreading knowledge, and creating ways for the community to understand the role of cultural heritage in promoting sustainable peace and development goals. I'm gonna end with this image over here. I made it in a way that each rail represents an international legal regime. On one side, we have cultural heritage. On the other side, we have international security, as a way to convey the message that each legal regime has its own goals, its own priorities, background assumptions, different enforcement potentials, and they mean to achieve different results. That's why it's so important to understand context when regimes overlap. And my final message here is that counterterrorism regime is actually crucial for recovering cultural objects used for terrorism purposes. But still, if a cultural object is recovered and is not managed according to heritage priorities, the regulation of cultural heritage is like these parallel rails. They seem to converge towards justice, but they never actually meet. It's just an optical illusion. Thanks so much. I'm sorry for the connection issues. And if you're interested in this topic, I just want to highlight this book, which was launched a couple of months ago on global perspectives on cultural property crime. The book addresses intersections of art, antiquities, and crime, including currency crimes. We have a chapter written by Associate Professor Constanze Musil about antiquities and terrorism financing. So if you're interested in this topic, it's worth checking this chapter. And I contributed with a chapter as well about the anti-money laundering regulation of cultural heritage, which is a bit same, but different. Same because the anti-money laundering regime is to a great extent, it relies on the same legal framework of the counterterrorism financing regime as for the FATF recommendations that I mentioned in my presentation. But it's different because, of course, money laundering and terrorism financing are very different crimes. Yeah, that was me. Thank you very much.
Thank you very much, Diego. And I'll pass it to Pascal now so that he can respond. And then I don't know whether we will have time from the floor because of the technical issues. About Pascal, the floor is yours. Oh, wonderful. We can see you, Diego.
It's working.
Hello, Diego. Thank you very much for this also very interesting communication and for your paper, which is also very, very interesting. I have a first question about your in English, the intitulé, the title of your thesis, which is the instrumentality of cultural heritage and international security for international security and vice versa. I have a question about the notion of international security. When I read you, when I listen to you, I think it's more the question of terrorism than the question of security. It's true that, of course, the terrorism raises a question of security, but international security is a broader concept than terrorism. For example, the UN has developed at the beginning of the century a new concept of security, of international security, which is human security, which includes health security, social security, environmental security. So is your title very precise regarding the subject you will deal with? I don't know if it's very clear.
Very good question, Pascal. That's actually true. I adopt this term international security as a way to justify a bit why the UN Security Council would regulate cultural heritage, for example. because my thesis is basically about overlapping legal regimes, how cultural heritage overlap with different legal regimes. In this case of my presentation here, counterterrorism and terrorism financing. But in my thesis, I develop as well about money laundering and international humanitarian law. So I use this term here, international security, as a way to explain why the Security Council would have a mandate to regulate cultural heritage, for example. But yeah, necessarily, and of course, international security is much broader than terrorism, even because the UN Security Council is much older than the international legal regime against terrorism, for example, right? But yeah, it's a way to explain why the UN Security Council would have a mandate to regulate cultural heritage, for example. That's why.
It's a good justification. Thank you. The other remark is, I think the main difficulty of your subject is that the legal framework of your research is quite narrow, is quite limited in reality. You have some national Security Council resolution. You have some counterterrorism rules, like the recommendation of the Financial Action Task Force. But I think the legal framework you have to study is quite narrow, and it will be difficult to only stay with this legal framework. And I think you will have to broaden what you will study. And I think perhaps your thesis, it's like in France we say it's a thesis of propositions. That you will propose some innovations in your work. Do you think you will have to propose reforms, new rules, new? I don't know if the thesis in Australia, the legal thesis, PhD in Australia, you have this methodology and you can propose some innovations. But I think it's a part of I think of your work because the actual legal framework is quite limited. The other point, I think perhaps you will have to study comparative law, how the main states deal with this question of counterterrorism and cultural heritage in order to enrich the legal framework you study.
Yeah, this question is really interesting for 2 points. The first of them is regarding the legal framework. I was about to ask you about which other international legal instruments you had in mind. For me, like to have a broader scope of my legal framework, but then for what I could capture, you're speaking about domestic legislation, right? When you speak about comparative studies, you're speaking about domestic legislation, right? Yeah, that was a very conscious decision that we made at the beginning of the thesis, that I would approach only international law. At first, I tried to address it in a more comprehensive way, and I was adopting literature on transnational legal orders, for example, that speak about this relationship between the international and the domestic and how they influence and impact each other. But then at a certain point, we realized that the theses were getting too broad, and we decided to adopt a different literature, actually more about fragmentation in international law. Because I was working basically with the international conventions and the legal instruments. So it was a way to narrow down. It was actually a conscious decision to do that. And your second questions about the propositions is interesting. And I guess that's why when I speak, why I'm interested in this topic, I start by saying about my professional experience, because when I started my PhD, I came with a lot of propositions as someone that was working in the field, and I was trying to write about it. And it's interesting that you can still capture this kind of initiative, because something that I learned during this journey is that my thesis is not mainly about propositions, but making a contribution to the field about the fragmentation of international law and the interaction of the cultural heritage regime with other regimes, and which priorities in the end are foregrounded when that happens. It's something that I didn't bring in my presentation, but the main topic of my research is actually a research about the values of cultural heritage. And when I do that and I explore the values of other legal regimes, I bring a contribution to the field about if cultural heritage has an intrinsic value, or how you can justify the protection of cultural heritage by extrinsic justifications, drawing on values of other regimes that cultural heritage interact with.
Okay, it's very convincing.
Diego, before we move to the next panelist, before I thank you, I wouldn't let go of the propositions. I think it's really valuable, especially if we're talking about law. If you come to it, you're guided by that, what has triggered you originally, because it's grounded in reality. I think it's a delicate line, though, in writing it then almost like a policy paper. And I think, as I'm sure that that's what Lucas will be guiding you about, is don't let go of that as to what that motivator was. I think it's really important. The other thing that Pascal raised, and I understand about the comparative aspects, but leave that to the postdoc later on when you finish the PhD. Yeah, it'll make a wonderful postdoctoral. If you're still wanting to do research in this field, that's something that you can do for your postdoc. So again,
absolutely, it's so interesting. The topic's so interesting, isn't it? Absolutely.
And you'll become the world. A wise person said to me, and he's not here, but another one of my supervisors also said to me, you will literally, and most of the people that are contributing to the doctoral colloquium, you will become the expert in the field, because you will have concentrated so many years in this field that you will literally, by the end of it, be the expert in the field in most cases. So yeah, don't let that go. And that's why it's really important to listen to the advice that you're getting, to make sure that that grounding is there as you advise people going forward. Now, thank you. A round of applause for Diego for his wonderful. Okay, now, Diego, we did all the teething things with your presentation, so hopefully it will go smoothly now for the third and final panelist. Da Hong Yu.
Hello.
Wonderful, wonderful. Good to see you, Hong Yu. You are from CUPSL. I never get that acronym correct, I'm sorry. And your wonderful contribution, and I'm not doing you justice by way of an introduction, is in relation to inalienability of cultural objects in international and internal law and the antique rule in modern world. Hong Yu, the floor is yours. And if you could share your...
my PPT.
Please.
Okay. I start now.
Yes, we can see.
Mesdames et Messieurs, bonjour. It is my honor here to share my understanding on this topic of inalienability of cultural objects at the level of international law and internal law. I aim to spend no more than 15 minutes talking, and then I would like to learn some comments from dear professors and fellow researchers. The last 6 decades have witnessed an enormous progress in international cultural heritage law, of which the milestone is the adoption of 1970 UNESCO Convention on the means of prohibiting and preventing the illicit import, export, and transfer of ownership of cultural property. In 1962, the General Conference of UNESCO considered an international convention as the most effective means of prohibiting and preventing the illicit export, import, and sale of cultural property. And in 1964, it reaffirmed the desirability of elaboration of an international convention. In 1968, following this hope, the Director General of UNESCO, with the help of Monsieur Hubert Brichet from France, prepared a preliminary study on this subject, stressed the necessity of establishing national inventory for inalienable cultural objects. We can see here the necessity of national inventory. The inalienability of cultural objects was mentioned here to fix reasonable limits to exchanges of cultural property and to the restrictions on its transfer. This report found that lawful transfers of cultural property should be encouraged, while other transfers of cultural property should be restricted when envisaging the drawing up of such an international convention. In light of this, the classification or characterization of inalienable cultural property can be regarded as an essential rule balancing both sides of speculation and control. In 1939, over 1 year afterwards, the preliminary draft convention was ready, which in its Article 10 incorporated the inalienability of cultural property. The original draft was only written in French, and the official translation in English is here. And as travaux préparatoires, the commentary of drafter to this draft consideration explains that special protection should be devised by all states on the lines of that practiced in states familiar with the idea of protection of state property, in French, protection domaniale, in which cultural property made over to a public collection is inalienable for all time, where a claim for recovery cannot be time-barred in the event of disappearance. The drafter further explains that a claim by a state despoiled of a cultural object and the recovery by the state of the object in question should constitute an indefeasible right, particularly if the object has been registered in a national inventory or belongs to a public collection. The commentary believes that a de facto violation cannot become de jure. The only comment or observation on the Article 10 of the preliminary draft comes from Austria in March of 1970, reads as follows. The classification in question could be carried out quite simply at the national level. So, it is not surprising that the draft convention for submission to the General Conference modified Article 10 of the preliminary draft by adding consistent with the laws of each state to the end of the introduction and retaining the subparagraph E without change. So Article 13, subparagraph D of the 1970 UNESCO Convention reads as follows. Article 13, the state parties to this convention also undertake consistent with the laws of each state to recognize the indefeasible right of each state party to this convention to classify and declare certain cultural property as inalienable, which should therefore ipso facto not be exported, and to facilitate recovery of such property by the state concerned in cases where it has been exported. The provision deserves careful attention. The complete name of the 1970 Convention suggests that two aspects are concerned. The first one is import and export control, and the second one is ownership control. The notion of protection domaniale was introduced here in that fighting against title laundering of cultural properties, taking advantage of time bar or time limitation. This very notion of protection domaniale happens to cover these two aspects, which is not an entirely coincidence, but originates from Occidental legal tradition with regard to antique law dealing with antiques, that is inalienability of cultural objects. According to Professor O'Keefe, who studied the example of French law, he said that while the article may not seem particularly clear to common law readers, it becomes clearer if an explanation is given of the civil law practice in cultural matters on which the article is based. We can see in Article L 451-5 of the current global patrimoine in French law provides that in its first paragraph, les biens constituant les collections de musées de France appartenant à une personne publique font partie de leur domaine public et sont à ce titre inaliénables. And in the second paragraph, toute décision de déclassement de ces biens ne peut être prise qu'après avis conformément au Conseil des musées de France, which means all cultural objects in the inventories of French museums served as public collection under the regime of domaine public can never be downgraded without the due consideration and specific permission of High Council of Museums of France. In the meantime, the Article L 451-7 of the same code provides that les biens incorporés dans les collections publiques appartenant au legs ou pour les collections ne relevant pas de l'État, ceux qui ont été acquis à l'aide de l'État, ne peuvent être déclassés, which forbids all cultural objects in such inventories identified as donation and bequests or acquired with the help of the state to be downgraded in any event set by this code. Considering that museums do not produce collections, just collect and preserve them for exhibitions and researches, etc., the majority of cultural objects in such inventories can hardly be exported leaving France and transferred to citizens of another country. This notion of protection domaniale and the principle of inalienability can be dated back to 1279, when an assembly of princes announced the inalienability of property of the crown, domaine de la couronne. We can also find in Roman law that the concept of res extra commercium, which means to guarantee public interest, certain objects cannot be sold. Inalienability of cultural objects in contemporary French law, as well as similar domestic legislations in the continental Europe, is rooted in Roman law tradition, meant for the property in uso publico, protecting ownership of objects for public use and denying time limitation. However, it shall be noted that other modes protecting cultural property do exist. In common law, designated use of cultural objects is insured by trust, such as in English law or in Australian law. In Chinese law, we do not apply the evident expression of inalienability, but classify cultural objects into different categories. The export control and ownership control are determined by such classification. Current Act for Cultural Objects Protection in Chinese law classifies movable cultural objects into two categories, precious cultural objects and regular one. In its second paragraph of Article 3, according to subparagraph 1 of 14th paragraph of Article 5, undiscovered cultural objects buried or excavated in China are owned by the state unless otherwise specified. Article 34 of the same Act requires cultural objects excavated to be incorporated into public collection. Pursuant to Article 51, state-owned cultural objects cannot be traded unless otherwise permitted by the state. Precious cultural objects in private museums cannot be traded either. It must be stressed that only licensed shops and auction houses can engage in business. In such business of trading cultural objects in Chinese law. Hence, licit export and transfer of ownership of cultural property in Chinese law shall enable the determination of provenance. Article 21 of Regulation on Museums, issued by the State Council, prohibits museums from acquiring cultural objects without clear and licit provenance. Meanwhile, a thorough classification of domain public imposing the inalienability of cultural objects has encountered modern difficulties. We may recall recent cases of restitution and return of several cultural objects from France to certain African countries. Although these cultural objects are regarded as inalienable and inseparable objects of moral importance in certain African countries, such as Benin and Madagascar, these objects are also inalienable and inseparable from French museums and French law. The complete return, both physically and legally, in both countries, France and Benin, can only be finally achieved by a special legislation in December of 2020. The reluctance and problematic situation may arise from the loose provenance examination at the time of acquisition of cultural objects by museum, combined with this absolute inalienability of the protection domaniale. We can also cite the case of golden plates illicitly excavated and exported from China. Back to the last decade of last century, some ancient tombs were excavated illegally in Li County of Gansu province in China. A set of golden plates were exported illegally from China and somehow ended integrated to the public collection of the National Guimet Museum in France. With the accidental discovery of the looting by a Chinese archaeologist during his visit to France, the Chinese government decided to repatriate this set of golden plates dated back before Qing dynasty, which are of great significance. French government and the National Guimet Museum suggested that this set of golden plates had become an inalienable part of French public collection, which is protected by this inalienability clause in French law concerning the return. Under Article 13 of the 1970 Convention, these cultural objects are inalienable, classified by China's internal law, and thus it constitutes an indefeasible right to ask France as another state party to implement import control and facilitate return of objects concerned. All of this can only be realized consistent with laws of each state, in this case, French law. Nevertheless, the Article 13 establishes an international obligation, limited but meaningful, to facilitate return of cultural objects to the country of origin in the most possible way. In this case, the donation of golden plates was effective and these objects were no longer inalienable. The private collectors returned these golden plates back to China. Early in the elaboration process of the 1970 Convention, it was pointed out that an effective and better international instrument regulating the circulation control of cultural objects between states can only be finally achieved by harmonization of internal law. This statement indicates perfectly the issue I raised today, that disputes over the ownership and return of certain cultural objects may arise from conflicting inalienability clauses in different domestic legislations, where international legal framework is incapable of responding. A de facto ownership of an object from the perspective of Benin may hardly be de jure, while the ownership is de jure and de facto under French law. In spite that an indefeasible right of such an object based on the state ownership can be recognized by another state possessing the object, it may be impossible to return the cultural object consistent with the law of the state possessing this object. Inalienability clause in domestic legislation, which can establish state ownership, may be in conflict of another such clause in another legislation. This territoriality and other difficulties we have talked today show the insufficiency of antique notion of protection domaniale and the antique rule of inalienability of cultural objects in a world where different states and legal traditions live. Multilateral dialogues and consensus need to be advanced, where the institutional effort of UNESCO can play a constructive role. Concerning this topic, I put forward today, when refusing restitution or return, the reasoning of inalienability of cultural objects cannot perfectly defend itself. Despite that moral argument and foreign law can hardly challenge internal legal regime, the rule becomes less convincing and less acceptable to foreign interested parties, given that the impossibility only arises from internal legislation, while a limited international obligation to return has been mentioned. International dialogues and the institutional agenda of UNESCO may work out better solutions, such as not applying this clause in the context of international recovery of cultural objects. I hope that this quick overview of this issue has been clear. Thank you for your attention. I'm now expecting comments to my presentation.
Thank you, Hong Yu. Thank you very, very much. I think you will be the only presenter that has satisfied everybody in the room that you've covered all 3 language groups that we are able to converse in or not able to converse in. So Pascal, the floor is yours in relation to response.
Thank you. Thank you very much, Hong Yu. First, I would like to tell you that I liked very much your paper you sent us, and which is very interesting. And I wanted to tell you also that your subject is very interesting, is fascinating. I think the question of the inalienability of cultural objects is a very interesting topic. You use the French law because effectively French law recognizes this notion of inalienability, and I think it's for you like a model for international law. I understand you propose to extend the use of this notion in international law, but I think this is a very interesting hypothesis and proposal. But I think the big question is the question of the regime of inalienability. Should the regime be defined by international law or by the different national laws? And because can there be a universal conception of inalienability, or this is national? Each country has its conception of inalienability. So this is a question of distribution of the competence between the national level and the international level about who decide what cultural object is inalienable and who is not inalienable. This is my first question. Second question is about the consequences of inalienability. Could you consider that when I read your paper that inalienability, the decision of inalienability of a cultural object can be retroactive? I don't know in English.
Yeah, retroactive.
Retroactive. It's very interesting because if you say it is retroactive, you understand you can have a kind of if you mixed retroactivity and extraterritoriality, you can say, okay, this object you have in the Louvre Museum is now inalienable under my national law. And according to international law, inalienability, a cultural object which is inalienable must be restituted to the country. So do you think this in your proposal, inalienability can be retroactive and can be extraterritorial? That's my second question.
Thank you very much. This topic is very interesting because it concerns 2 aspects: the interaction between international law and the national law, and interaction between public international law and private international law. So for the first question, I think based on the research I have done, the main actor who decides the clause, the inalienability of cultural objects, is the national legislators. Although we have seen this international provision, but this international provision is limited, it's so limited, and this limitation is foreseen by the drafters of the 1917 convention. And for the second question, the inalienability clause, the inalienability of this object, in most continental European legislations, it cannot be retracted In this case, it can be retracted because it's a private donation. The donator is alive, and it's possible to achieve a resolution of this contract, the donating contract. But in most cases, the donators are already passed away, and in French law, I have mentioned earlier, it cannot be traded and be transferred. So I think the true question, the true difficulty here is the inharmony nature between multiple states. One state considered it as considers this object as an inalienable object, and the other state also consider it as an inalienable object. It is a very, very hard question, and it was deeper research. Thank you.
Thank you very much, Hongyu. Thank you very much for your intervention, and I'd like to thank all three panelists for their intervention in our first session, which we're deeply grateful for. So Yasmina, Diego, and Hongyu, and that has synergies within them, which was wonderful. And I've got to thank Pascal for your clearly very detailed examination of the papers. So we're grateful to all the first panelists and our discussant. A round of applause, please. Now we'll take a few minutes to set up the next session, if we could. We're going to be very strict about the times for the next session, because there'll be a lot of hangry people not being fed for a while, because it'll be 2 o'clock here. So a few minutes before we set up for the next session, please. Thank you for your patience. So we'll go on mute now if we can. This cannot.
So welcome to the second session of this doctoral colloquium on cultural heritage law, so new developments in international cultural heritage law. We're having 4 speakers today now. So the discussant is going to Professor Gao Shang from Shandong University of Technology and Science, who is joining us online. We have 1 speaker online, Chen Rida, who is going to be the first speaker. We will be followed by Li Mei So, who's sitting next to me, and Nicolas Augustinus. And then we're having David Richello. So I would ask, thank you, I would ask all 4 speakers to please stay within the time limit of 15 minutes, and for the discussant to please ask 1 or 2 questions. So could Chen Rida join us online, please?
Yes, thank you.
Yes,
Thank you, Professor Sylvia Vinerant. I would like to share my slides first.
So Shen is from the China University of Political Science and Law. Thank you, the floor is yours.
Thank you, Professor, for holding this session. Good morning from Beijing. My name is Rida Chen from China University of Political Science and Law. And it's a great pleasure to share my research here with you. So today I would like to share some insights into a long discussed question, the restitutions of the colonial cultural property, and from a specific perspective of China. And I'm really happy that to hear that some of you discussed about the Chinese cultural objects at the very beginnings of this morning. And as we all know, the late modern periods of the humankind has witnessed the damage and destructions of the cultural heritage and the looting and smugglings of cultural objects through war or colonial occupation, which as a result deprived access of the local people towards their indispensable cultural identity. As China was one of the countries that experienced colonialism and loss of cultural objects because of it, my presentations will provide firstly an overview of the Chinese cultural objects lost over the periods between the 1840s to 1949, and analyzing the characters of the loss and the dilemmas when planning for their return. I will also propose in briefly the notions of the cultural sovereignty for the negotiation for the restitutions under the ethical basis. So in general, cultural objects were lost from China during this period in 3 ways: looting and plunder, cultural expeditions, and illicit trade. First of all, is the looting and plunders. As we know, the Opium Wars from the 1840s are usually marked as the starting point of the Chinese modern history. One of the most extreme examples of the imperialist aggression goes to the looting and destruction of the Old Summer Palace during the Second Opium War. And many of their trophies, such as the bronze, proclaims, calligraphies, and seals, were sold or auctioned directly around the military camp in Beijing, some of which were finally transferred to the Western museums and the private markets. The Boxer War at the beginnings of the 20th century was another major event that resulted in a wider scale of looting and illicit trade of not only the imperial collections, but also the private ones. The second ways of lost cultural objects from China is by the cultural expansion or the colonial exploration. The late modern periods also witnessed the unlawful excavations and traffickings of Chinese cultural objects, especially in the northwestern China, such as the Dunhuang Mogao grottos. The excavations and destroys carried by the foreign archaeologists or adventurers were usually obscured as cultural expeditions or Eastern exploration. However, the legitimate of the so-called exploring activities was in a gray area, when what were cultural expeditions in appearance was in fact colonial exploration by nature. The third way is illicit trade, with strong temptations of benefit by the art market highlighting the Eastern art around the 1920s. Some of art dealers and curators from China and overseas were also participating in the smuggling of cultural objects from China, among which the dealers and curators from Japan played an important role. Industrialized smuggling chains were set up between the Chinese heritage sites and the Western markets. And finally, the growth of colonial powers and the interest in the Asian art market have triggered more looting, theft, and illegal exports of cultural objects from China, making it a critical period that China lost numerous cultural objects around the world. When we deal with the restitution cases of cultural objects looted from the colonial context, the burden of provenance is the first of great importance, not only from the collector side, but also from the source countries. Among recent years, as we know, the long-term process of decolonization among major Western museums by returning their collections to the countries of origins has shown much progress. In this case, the museums are increasingly under pressure to not only make sure that the new accessions has the legal histories of transferring, but also initiate some projects dealing with their current collections and review their legal basis at a more comprehensive dimension. We could find, for example, that from the Icon Code of Ethics for Museums, that provenance research prior to the acquisitions of the cultural objects is the undertakings by the museums. And the duties of provenance research on current collections refers to a further devotions and actions of the museum to cooperate in the returns of cultural objects back to their countries of origin. When the object is placed at the market today, the due diligence requirement is also for dealers. Is also part of the duties of the art dealers, as provided by the International Code of Ethics for dealers in cultural property and other moral principles or legal instruments applied to the dealers. However, it is not always simple for not only the museums and the dealers, but also the source countries to have a full picture of the histories of the cultural objects in question. So it is a problem about two sides of the same coin. From the destination state side, some museums who receive donations from the colony in the histories may be faced with a problem of provenance research, since the times of colonial plunderings and collectings was claimed to be times of the imperial bright eye to optimistic collecting in some empires. Due to the lapse of times and weaker documentation, comprehensive provenance research over the collections from colonial context would be more difficult. The other side of the coin of provenance research regarding cultural objects from colonial context lays on the burdens of proof of the evidence on the requesting countries, who usually need to provide a convincing support on whether the objects originated within the border of their own territory. We have two typical cases that check the claiming states by the burden of proof of the origins of the cultural objects in question. That is the Italy versus Getty museums over the status of the victorious use and the government's approval versus Johnson's before the U.S. court. And two typical cases from China concerning the provenance research about the lost cultural objects from the colonial context may help to illustrate this situation as well. Case one is the cultural objects from the old summer palace. The specific provenance of some of them in the Western museums and open markets remains vague or even false because it is a convenient and secure basis to label the objects in the markets from the 19th century. China's is in the market as from the Imperial Summer Palace packing, which contributes to the final price of the objects. Case 2 is the cultural objects from the cave temples, such as the Zhonghua Mogao grottos. It's usually argued that only by referring to the cultural link between the objects and the claimants cannot sufficiently prove that an object was originated from its specific territory. For the cultural objects from cave temples or other heritage sites in the northwestern China, the provenance is under challenge by some Western collectors or curators by claiming that the objects may not exist in the borders of the old China when it was created. When it comes to the legal dilemma, domestic law and the international instruments are two main divisions that may provide support or obstacles for the restitution cases. There are serious regulations about the protections of cultural objects in China during the colonial era. For example, the Greeting Code, the measures for the preservation and promotions of monuments, the interim measures for the preservations of antiquities, and the old ordinance for the preservations of monuments and antiquities, as well as the law on the preservations of antiquities. For some reason, I won't go into details of them, but it's began dubbed that the smugglings of cultural objects during the colonial era in China had drawn attention of the legislators at that time, and a series of regulations were issued to prevent further loss and destruction. The relevant regulations provided a clear rule that destruction and theft of cultural objects were prohibited and would be punished by law. To some extent, the state ownerships of the cultural objects were also recognized. However, the principles of bona fide acquisitions and limitation periods for claims played another important role in the modern private law systems. And these rules don't usually favor the restitutions of cultural objects and may become obstacles to the restitution, on the other hand. At the international level, there were a series of conventions concluded after the Second World War for the combating of illicit trafficking of cultural property. However, due to their knowledge attitude, narrow preambles, and limited numbers of state parties, as well as their weak implementation, their functions on the restitutions of cultural objects from colonial contexts cannot be overestimated, which has also been addressed by Professor Gaoshen yesterday. However, we can refer to some soft law instruments, for example, the ICPRCP or the resolution adopted by the UN General Assembly concerning restitutions of works of art. They also called for attentions of the independent rights of the countries used to be under colonial controls or occupation, and the prohibitions of transactions and the restitution of works of art looted from these countries. As Professor Sylvia Vinerons already said yesterday, soft law in the modern times plays an important role in the achievements of the SDGs. A statement by the Chinese delegations to UN in 1973 can also be quoted as they declared that cultural objects looted, stolen, or removed from China during the colonial context was treated as destructive to the cultural identity of the Chinese people. Well, to conclude, the post-colonialism trend is a way to overcome the problems left by the past to the current generation of us. The stories of cultural objects from being lost and recovered is a whole process showing how the cultural sovereignty and cultural confidence of a civilization, a country, or an indigenous community is deprived, rebuilt, and then enhanced, which constitute the motivation for us to talk about cultural decolonization. Cultural sovereignty is the inner characteristics of a nation which nourishes the existence and development of the nation, and it is rooted deeply into the cultural identities and spiritual value of the nation. Under the conditions of respect for the cultural sovereignty, the basis for the returns and restitutions of cultural objects from colonial contexts could be discussed beyond the spheres of only applying the ownership laws and international conventions, with a broader reliance on ethical principles and mutual understandings instead. That's all. Thank you for your patience and your listening. And I would like to receive any comments from you for further discussion. And I also hope to meet you in person in the future. Thank you.
Thank you. I do hope we will meet in person in the future indeed. And thank you for your very good timekeeping. Professor Gao. Professor Gao Shang.
Maybe it's the audio, isn't it?
Yeah.
You need to ask.
They might need to help.
Can you
I think it's a translating service.
Here, can you hear us? I can't hear you.
No, I think it's a translating service. He needs to speak and then.
Yeah, but it's not long. Is that a mute sign in the corner?
能听到，能听到。
Okay, we can hear you. I don't understand, but we can hear you.
Professor Gao, if you could do your intervention in response to that paper, that would be wonderful.
好的，谢谢，感谢苏菲教授，非常荣幸参加这次博士论坛。
Do we have a
对
translator?
我本人来讲，也是一次难得的学习机会。刚才陈博士分析了中国殖民时期文物流失的主要途径，对所面临的困境，既有关于文物身份来源证明面临的困难，也有国内法律制度欠缺，还有国际立法的局限性分析。同时作者从文化主权的概念出发呢，来证明了文物返还不是一个简单的所有权证明和归属问题。这里呢有两个问题，可以和陈博士来交流一下。第一个问题呢，就你所了解的，就是目前中国政府或者民间在追索殖民时期非法流失文物方面采取的一些你认为是非常有效的措施有哪一些？这是第一个问题。那么第二个问题呢，刚才作者在文中以文化主权的理念来作为追索文物的一种有力的一种正当性的一个证明。那么如何将这个理念落实，让它成为推动文物返还的一个强大动力，而不能成为阻碍文物返还的一种理念？这两个问题请陈博士回应一下。
Okay, great. Thank you, Professor Carlson. And I'm not sure if you could hear the translator.
We could not hear the translator, so it would be great if you could just translate just the questions, just the questions, and then your answer.
Yes, of course. Yes, I received 2 questions from Professor Carlson, and I'm really grateful, and because it's really interesting. And I also really like to go into the details of these 2 questions. The first question is that Professor Carlson asked, are there any like successful ways that China claims for the returns of the cultural objects that lost during the colonial era? Professor Carlson's question is that what do I think is the most useful, the most successful way to claim for such return? Well, as far as I'm concerned, there are some cultural objects that that have already been returned to China. For example, we have a Buddha statues that was used to be auctioned in Japan in 2020, and after this, the boss, the managers of the auction house bought such Buddha statues and then returned it to the Chinese government as a personal gift. So by the ways of purchasing, and this is one of the major ways that Chinese governments or the Chinese civilizations are claiming for the returns of their cultural objects. But I don't think this is is a sustainable way to claim for such returns, because usually you need to make a claim, you need to purchase, and you also need a donators or something. So I think this is not sustainable, and I think it's better to bring this to bring the claim by bilateral negotiations or even by litigation. But as we know, suing another government or museums for the returns of cultural properties from the backgrounds of colonialism is not a very easy ways, because you need to prove like that you have the real ownerships, and you also have a lot of legal issues that you need to deal with. So I think this is still a good question to look into the negotiations between at the levels of the governments or at the levels of civilization. So this is the first question. And the next question Professor Carlson asked is that how could we implement the notions of cultural sovereignty? I think this is really question, and I think I will also go into the details of them in my following.
Can you please shorten your answer?
Okay, of course, thank you.
We're short of time, we still have 3 minutes.
Of course,
Sorry about
okay,
that.
for
It's really
the
interesting.
cultural sovereignty, I think we can implement them by like negotiations, and we can also put it into the resolutions of some international organizations such as the UNESCO General Assembly's resolution. We can put these kinds of notion, and we can also like implement it by national legislation and so on. But I think this is still an open question, and I will also continue to look into it in my future research. Thank you.
Yes, thank you. I think this notion of cultural sovereignty and how it could contribute to the restitution claim is really interesting and something to develop further. Thank you.
Thank you, Professor.
So our second speaker is Li Meso, who is going to talk about from monumental to intangible cultural diversity and New South Wales planning and environmental law, and she's from UTS here. So,
Thank you. I wanted to give my presentation, which is going to be brief, a bit of context. Firstly, I'd like to mention that in preparation for today, I put together a 5,000 word paper, which sets out a lot more detail than what I'll be going through shortly. Secondly, the other context is that I've only recently started my research mid this year, and I came about to undertake the research because of my legal practice background as a member of the local bar here in Sydney. I am a specialist litigation lawyer who appears in our domestic planning and environment court here in Sydney and New South Wales. Also, the other motivation is being myself an Australian-born Malaysian Chinese, member of the migrant community here. So my parents migrated to Australia in the 1970s from Malaysia, but originally members of my grandparents' generation are from China. So I'm talking today about a very limited aspect of my research, and really what will form, in my mind, one chapter of my thesis, and that is the context of the domestic New South Wales, what I'm now badging as the heritage planning legal framework, which follows on ideas addressed by Ben Bohr and others that have come before me and Morris Evans about the need to integrate heritage and planning law. So the content of domestic New South Wales heritage planning legislation is rarely the subject of texts and publications. In my mind, this is problematic, first for three reasons. Firstly, because international cultural heritage law is implemented by domestic law. Secondly, because it is difficult to assess the utility, impact, and relevance of cultural heritage research for practicing domestic heritage planning lawyers and experts without a clear understanding of domestic heritage planning legislative frameworks and the operation of such frameworks. And thirdly, because marginalised migrant heritage is most likely under current regimes to be of state or local heritage significance. Work on addressing the position of marginalised migrant communities under heritage planning law and policy cannot properly begin without a clear understanding of domestic heritage planning legislative frameworks and the operation of such frameworks. So here in New South Wales, the local heritage planning legislative framework consists of two key pieces of legislation. That is the state level New South Wales Heritage Act 1997 and the also state level Environmental Planning and Assessment Act 1979. Across these two pieces of legislation, it's an expert process of heritage assessment or assessments of heritage significance, which are undertaken by heritage and planning experts that links concepts of heritage across the two pieces of legislation. The Heritage Act governs listing of state and heritage significant of items of state and state heritage significance, making of interim heritage orders for items of state or local heritage significance, and applications for approval to demolish or alter an item of state or local heritage significance. The EPA Act governs processes of development approval. So in particular, under subsection 4.15, 1A, Roman numeral I and Roman numeral III, a consent authority is required to take into consideration impacts on heritage items and contributory heritage items in a heritage conservation area as part of provisions in local environmental plans and development control plans, respectively. As I mentioned, central to all these processes are assessments of heritage impact and heritage significance by heritage experts. In order to guide considerations of heritage, where an application for development approval is made under the EPA Act, the Land Environment Court of New South Wales has developed, through case law, what are called, in our specialist jurisdiction, planning principles. So there's two or three areas of planning principles that are relevant in a heritage context. The first is set out in a decision of Michael Hess and Parramatta City Council. It's a 2003 decision of the Land Environment Court, which sets out the planning principle when it comes to adductive reuse. I'm not going to go into the content of these principles in detail. They're set out in detail in my paper. Next, there is the decision of Hellu and Strathfield Municipal Council, which is a 2006 decision of the Land Environment Court, which provides the court's planning principle about demolition of a contributory item in a local heritage conservation area. The planning principle in Hellu has been applied by analogy to listed local heritage items in the cases of Norm Fletcher and Associates against Strathfield Municipal Council. That's a 2013 decision of the Land Environment Court, and the decision of Nader and Strathfield Council, which is a 2015 decision of the Land Environment Court. So just last year, there was a review of the Heritage Act conducted, and on the 22nd of April last year, the New South Wales Legislative Council Standing Committee on Social Issues published Report 59, Review of the Heritage Act, 1997. The report refers to the polar nature of oral and written submission evidence that was given in the inquiry about the overall inadequacy of the Heritage Act. The Standing Committee on Social Issues at page 29 said, the committee believes that more should be done to enable the identification, protection, and management of intangible cultural heritage. But whether this is best achieved by legislating for intangible cultural heritage through changes to the Heritage Act or through policy interventions, such as the Victorian framework referred to in evidence, requires more detailed investigation. So recently I spoke to some people at the Department of Planning about where that report is up to, and what I've been told is it's sitting internally with Department of Planning still, and that hopefully in the next year, because we're about to have a change of government, it's anticipated, there might be some action on the recommendations that are listed in that report. So as I said, I was only intending to be short, and I've only given a very brief overview of what the New South Wales Heritage Planning framework here is. You can see from my review of the framework that the legislation is silent about intangible cultural heritage, and that's what the review of the Heritage Act focused on last year in the quote that I just read out. My concern, I guess, is that while the legislation is silent about aspects such as intangible cultural heritage and the need for recognition of cultural diversity and cultural pluralism as central to the identity of modern Australian communities, that this creates certain problems. So in the absence of specific wording and terminology on these aspects, in my view, quite heavy burdens are placed on heritage planning experts, as well as on, and their processes of heritage assessment, as well as in court context litigators in proceedings before the Land Environment Court. And of course, within court context and outside of court context, members of the communities, marginalised migrant communities themselves, via processes of public participation, to identify and enforce the recognition, protection and conservation of migrant heritage in particular.
Thank you, Lee May. That's really interesting. I find it really interesting as well because in England, really the planning policies are defined by the government, not by the court. So that's really something. But I'm going to ask first, Professor Gao, if you can hear me. We haven't got a translator here with us. So is it possible for you to ask your questions in English? I'm sorry to ask, or is anyone able to translate Professor Gao's question if it's in Chinese? Because I'm afraid.
Thank you, Professor Sufi. Thank you, Professor Sufi. I would like to present two questions.
Very good. Yeah, go on.
The first of all, how to protect the minorities' rights during the heritage plan?
How to protect minority rights? I think that's quite a broad question, but I guess what I've highlighted in my talk is that there's the processes outside of court, and then there's the processes within court. So I think when, one of the issues is that in order for items of minority heritage, minority groups to be recognised, our system here relies heavily on most likely members of those minority groups to actually make an application to say this site ought to be is of heritage significance to our community and put that forward, or otherwise, somebody else who a member of the community or government who, is of the view that the site is of significance to the local community, which is, of course, is problematic because that's then not the community itself saying that the heritage is of significance to it. So I guess, one of the case studies in my research will focus on the Chinese Australian community. And what that means is that under our heritage listings, like in other places, if you look at places of public worship, for example, there are far more Christian places of public worship listed and heritage protected than, for example, Chinese places or Muslim places of public worship. Probably in order to enforce minority rights, I think it's a complex issue because I don't think minority communities have as much education and awareness here as, for example, Indigenous communities do. Because we heard from the Indigenous communities yesterday about how they continue to have significant issues, but their community is quite proactive, whereas minority communities here, particularly the marginalised minority communities, are not so proactive in my view. And so I guess I'm hoping that my research will be able to have some impact in reaching out to some of the minority communities and interviewing them and highlighting, and asking them perhaps what sites are of significance to them and how the system might better be improved to allow them to participate, because that's probably not really happening, I think.
Yeah, I think that also echoes what was said yesterday by First Nation speakers when they said about how can the law, and when we talk about social justice as well, it's about how the law can help you achieve the goals that you want to reach. So empirical research, communication, and sharing information also gives impact to our research. Very good. So thank you. I think we're going to move out. So thank you, Professor Gao, for this question. We're going to move now to our next speaker because we are the time is already moving on. So the next speaker, Nicholas Augustinus, who is also doing a PhD at University
University of Queensland.
University of Queensland, thank you. He's going to speak about the use of the right to freedom of religion in international rights litigation to pursue cultural heritage claims. So the floor is yours, and please stay within the 15 minutes.
And my thanks to the organisers of today's colloquium for inviting me to present my doctoral research, and my thanks to my supervisors, Professor Craig Forrest and Professor Lucas Lezinski, for their support of my research efforts. Now, the specific context of my presentation today concerns the assertion of rights by the Autocephalous Greek Orthodox Church of Cyprus with respect to its religious sites in northern Cyprus. Following the 1974 invasion and occupation of northern Cyprus by Turkey, and my paper provides the reasons which support the use of this terminology, the overwhelming majority of northern Cyprus's Greek Cypriot population was displaced, and the occupation authorities passed the decrees divesting the church of ownership of its artifacts and sites located in the occupied area. And as a result of the organised theft networks which operated in the occupied area following the 1974 conflict, the church sustained extensive damage to and loss of its religious cultural heritage. And the church's experience is familiar to cultural heritage law specialists through two significant cultural heritage law precedents, which have been created as a result of the church's international campaign aimed at recovery of its stolen artifacts, which have been trafficked by art theft networks, the Goldberg case and the Lands case. Now, these cases are essentially concerned with the church's engagement with law in order to recover artifacts. And they are given extensive consideration in my thesis. And that's an example of some of the artifacts that were recovered following Goldberg, and then further artifacts from the Goldberg case, and then from the Lands case. But actually the church lost the Lands case, and Dutch Parliament had to pass a law which eventually led to the recovery following the case. And one more. Thank you. But beyond artifact recovery lies the question of the restoration of these artifacts to their original context as part of a living culture. And it is this question and the activation of applicable international law necessary to support such restoration to context which constitute the central focus of my presentation today. So that's the original context of the Goldberg recoveries. That's the Panagia Kanakariali Francomi church, and that's the apse of the church from where they came from. And then that's the original context of the Lands recovery. And that's a shot of what it looked like before the events of 1974. So as it was in its original context, 16th century icons in a 12th century church. But in order for restoration to occur, the church needs to exercise something which it currently does not have. And that's free access to and control of its northern Cyprus sites. And the church has submitted complaints against Turkey about this state of affairs before the European Court of Human Rights. These complaints, however, have not been upheld by the court. Now, before I comment on the two unsuccessful European Court of Human Rights cases initiated by the church, and they're the two, the Chrysostomos case and the Pavlidis case, I wish to set out my argument concerning the church's engagement with human rights law and its assertion of rights with respect to site access. In my paper, I critique the court's judgments in these cases and argue that in failing to uphold the church's complaints, the court lost sight of international cultural heritage law, and as a result, legitimised the violation of the rights of people living under occupation. My critique builds on and intervenes in two existing broader conversations which are directly relevant to the matter at hand. The first conversation concerns Ferrari and Benzo's proposed model based on a convergence of human rights law concerning freedom of religion and cultural heritage law to govern the legal regulation of places of religious worship and significant sacred places in particular. The second conversation concerns A.L. Gross's analysis of the international law of occupation, and especially his focus on various other European Court of Human Rights cases concerning Northern Cyprus. The relationship between human rights law and cultural heritage law, specifically in the context of a church asserting access claims to its ancestral places of worship affected by occupation and displacement, lies at the root of my paper's intervention and connects the two conversations. Now, Gross makes the point that in addition to applying the European Convention on Human Rights, the court operates on the understanding that it is supposed to take into account relevant rules of international law in its own jurisprudence. The court, however, failed to do this over the course of its decisions in the Cypriot cases Gross examines. He consequently argues that the court's decision to adhere only to human rights law and ignore international humanitarian law did subsequently affect an eventual shift in its case law concerning Northern Cyprus that led it to depart from what the law of occupation would have required. Now, Gross does not examine the Chrysostomos case and the Pavlidis case. Using these cases, I make the point that the court also lost sight of international cultural heritage law. In the Chrysostomos case, the church, through its head, the archbishop, on behalf of the whole church, made complaints under a number of articles of the Convention against Turkey. Articles 3, 9, 11, 14, and Article 1 of Protocol number 1, in respect of the lack of access and enjoyment of the church's property in occupied Cyprus, particularly the church's inability to hold religious services at the religious sites belonging to the church in the occupied area. For the purposes of this presentation, I'm going to focus on the freedom of religion complaint made under Article 9. The complaint was held to be inadmissible. The court's rationale appears to be that this complaint concerned the ability to enjoy the property concerned and therefore was inextricably linked to the church's property claim regarding lack of access and enjoyment of the church's property in the occupied area, a claim which was also held to be inadmissible. And the property claim was essentially rejected on the basis of the application of the subsidiarity principle, which requires the claimant to exhaust domestic remedies before its claim can be accepted by the court. And what are these domestic remedies? Even though the creation of the TRNC, that's the occupational authorities in the north, have been declared by United Nations Security Council resolutions 541 and 550 to be legally invalid, in certain prior decisions concerning Northern Cyprus, and especially the Demopoulos case, the court accepted the TRNC as a de facto entity for certain purposes relating to the giving effect of these domestic remedies. In particular, it legitimised the TRNC court system and its immovable property commission for the purpose of dealing with the property claims of Greek Cypriot refugees and directed such persons to submit their claims to that system as part of the exhaustion of domestic remedies. Now, in the Chrysostomos case, the court relied on this prior decision and effectively gave the same direction to the church, both with respect to its property claim and with respect to its freedom of religion claim, which it regarded as being inextricably linked to the property claim. The Chrysostomos decision and its reliance on Demopoulos has extraordinary implications for the church's heritage claims in the occupied area. It effectively treats the church's religious sites in the occupied area, including its historically significant sacred places, as mere property, to be potentially exchanged or financially compensated, and directs the church to seek redress in a tribunal that is reluctant to grant restitution. This outcome ignores important norms of international cultural heritage law established by the 1954 Hague Convention and which has been ratified by Turkey, especially Articles 4.3 and 5.1, which require the occupier to support the competent national authorities of the occupied country in safeguarding and preserving its cultural property, and which further require the occupier to prohibit any form of theft, pillage, misappropriation, or vandalism of cultural property in the occupied country. The Pavlidis case concerns a visit to the historic Church of St. Barnabas in the occupied territory, which a group of Greek Orthodox faithful, together with the bishop, believed they had permission from the TRNC authorities to conduct for the purposes of taking part in the liturgy, which was to take place at the church. They crossed the dividing line, arrived at the site, and commenced the liturgy, only to discover halfway through the service that the permission that they believed had been given for the service to take place had been revoked. This became apparent when TRNC authorities descended on the site and committed an act of sacrilege by forcefully interrupting and terminating the liturgy and sending the participants back to the government-controlled area. The bishop who took part in the service, together with another individual, claimed a violation of Article 9 before the court in respect of the incident. That claim was not upheld. Now, the first point to be made about this decision is that it extends recognition to the laws of the occupation authority. This becomes apparent when it is seen that limitations may legitimately be imposed on manifestations of religion and belief that are in principle protected by Article 9 of the Convention. Under Article 9.2, to be legitimate, limitations on religious freedom must meet three requirements. They must be established by law, must pursue legitimate aims, and must be necessary in a democratic society. The court found that these requirements were fulfilled when the TRNC authorities interrupted and terminated the liturgy. This confirms in the religious freedom context the point made by Gross, that the court has extended legal recognition to various acts committed by the TRNC in a way which legitimizes the TRNC and such that the question of the existence of an occupation by Turkey in northern Cyprus under international law is rendered indeterminate. The problem is, however, that such legal recognition in this specific context also extends to those TRNC laws that have divested the church of ownership of its sites in northern Cyprus. Such recognition ignores important norms of international cultural heritage law that declare this transfer of ownership of the church's cultural property to be illicit. Article 9.1a of the Second Protocol of the 1954 Hague Convention, which Turkey has not ratified, and Article 11 of the 1970 UNESCO Convention, which Turkey has ratified. Second point to be made about the decision is that it suggests for a violation of the right to religious freedom to be recognised by the European Court of Human Rights, the relevant religious site needs to be the applicant's local parish, where the applicant had always worshipped on a regular or constant basis, and that the site is the only place where the applicant could meet to worship. And the fact that the applicant was only a small child in 1974 who did not regularly worship at the site up until that time, and the fact that the applicant is free to worship in the government-controlled part of Cyprus precluded a finding that a religious freedom violation had occurred. But these determinations completely ignore the significance of the site as heritage. Is it just the refugees who are now dying out who have a right to religious freedom at these sites? I think the court misses the point. Just because you are free to worship elsewhere does not detract from the fact that contact with important elements of spiritual heritage is being denied. To conclude, there is much to recommend in the Ferrari and Benzone model and its accompanying guidelines, but care is required when the model's convergence thesis, with its central focus on human rights law and the right to freedom of religion in particular, is applied in a context such as that currently prevailing in Northern Cyprus. The Chrysostomos case and the Pavlidis case highlight that the application of this right and its qualifications at law in a context of occupation and displacement can give rise to two problems. Firstly, legal recognition might be extended to certain acts of an occupation regime whose creation has been declared to be illegal and void. And secondly, important norms sourced in cultural heritage law might also be ignored. And finally, as regards our broader understanding of cultural heritage law, these cases show that the tactical use of human rights law and mechanisms underscores the way in which cultural heritage law regimes rely on other frameworks for enforcement at the cost of centering these other regimes. And that cultural heritage law lacks the ability to fully contain disputes, and that legal frameworks that center heritage more often than not serve supporting roles as part of an assertion of a convergence of rights aimed at restoration of a living cultural context. Thank you.
Excellent. We do have questions. Do you have questions from Professor Gao?
Yeah, one question.
Yes.
Yes, please. We're listening.
So in what ways shall the church to successfully assert the human right to freedom of religion in the European Court of Human Rights?
Okay, so I didn't quite understand the question. So
you might need to repeat the question, Professor Gao.
Or maybe type it. Yeah.
Can you please repeat
in what
the question?
ways shall the church to successfully assert the human right to freedom of religion in the European Court of Human Rights?
Okay, what will it take for the church to do that? I think the church has tried, and these are the outcomes that have come through from the cases. I think some further thought needs to be that a closer reflection on the fact that these other norms of international cultural heritage law were missed. I don't know how that message can be conveyed to the European Court of Human Rights. I think in subsequent case law, they become more attuned to looking at other relevant legal principles of law and not just focusing on the Human Rights Convention. But I think we missed the boat on that in connection with the Cyprus and the church's claim in Cyprus.
Thank you. Anna, do you have a question?
No, not a question, just an observation, Nick. I think just in another context, I've seen judges at the European Court of Human Rights actually ask, particularly academics, to write in areas where they have thorny issues. So I would absolutely encourage you to publish your research, because I suspect that it will inform the judges going forward.
Thank you.
Thank you. So as I'm really aware of the time, and we have one last speaker, who's David Ricciello from UTS, who's going to talk about the Valletta Convention in a Mediterranean setting, a new legal realist analysis of effectiveness. Thank you. The floor is yours.
Thank you for being here. The effective realisation of any transnational treaty on cultural heritage depends on how the treaty is brought into domestic law, its transposition, and how the domestic law is actually implemented by signatory members. Although considerations of treaty law have traditionally focused on the transposition phase, there has been a growing impetus in recent years towards research on the implementation phase. These studies show that the final product may not always reflect what was originally envisaged. Indeed, as an archaeologist, I've encountered many occasions where well-meaning laws and protocols relating to cultural heritage protection have proven ineffective or even counterproductive once implemented on the ground. Given the above, This paper briefly explores issues of implementation in the context of the Council of Europe's 1992 Convention on the Protection of Archaeological Heritage, otherwise referred to as the Valletta Convention, or for our purposes, just the Convention. Drawing upon the preliminary review of the literature undertaken as part of my doctoral project, this paper will first argue that the current evaluations of the Convention, 1, underrepresent the experiences of some member states, 2, rarely consider the influence of local context on its implementation in practice, and 3, lack a systematic framework for assessing its effectiveness for archaeological heritage protection and management. Inspired by new legal realism, the second section of this article will propose that a possible solution to these issues is the development of an empirical effectiveness test that can provide standardized measurements of the Convention's effectiveness across multiple international settings. Focusing here on one of my Mediterranean case studies, namely Greece, it will be briefly demonstrated how such a tool can be used to highlight the effectiveness of the Convention's regional implementation from both a de jure and de facto perspective. Next slide. Addressing calls for greater heritage protection against growing development activities in Europe, the Convention provides a framework that deals with elements, including the identification of and protection of heritage, the integration of its convention with urban planning, and the funding and dissemination of archaeological research. Notwithstanding its near universal endorsement of 46 ratifications and its importance to archaeological practices in Europe, the Convention has been the subject of a considerable amount of academic scrutiny and critique. For instance, a survey by the European Archaeologists Consortium revealed that whilst there was a general consensus amongst its members that the Convention was successfully applied within their country, a majority of respondents also agreed that serious problems were encountered during its implementation phase. Next slide. The scholarship regarding the Convention's application can be loosely categorized under one of two thematic foci: case studies of the Convention's implementation by individual member states, or comparative research of the Convention across multiple countries. Case studies devoted to the subject of national implementation vary considerably with respect to the number of studies undertaken on individual countries. This point is readily illustrated when considering the amount of coverage afforded to the Convention in the respective settings of Greece and the Netherlands. Only one author, to the best of my knowledge, has explicitly discussed the Convention in the context of archaeological and legal measures in Greece. By contrast,